Welcome, everybody. Welcome to today's episode of the Law of Self-Defense. I am, of course, Attorney Andrew Branca for the Law of Self-Defense. And today we have a show that all of you have been demanding I catch up on, and that is, of course, the Apple River stabbing trial taking place in Wisconsin. It started Monday. Of course, Monday, Tuesday, Wednesday, I was doing a rewatch of the Zachariah Anderson trial, which I kind of committed to up front, having been out of the office for a while, and this had the Apple River case had kind of fallen off. Excuse me, folks. And so this trial started Monday, Tuesday, Wednesday. I was doing the Anderson trial, but now I'm going to rewind the Apple River stabbing trial back to Monday, start with opening statements, and see how far we can get. Now, I do have an unavoidable commitment in the middle of the day today. Nothing I can do about that. Hopefully, we can get through the opening statements and I can provide some background on the relevant self-defense law here, provide some legal context. I will have to bow out in the middle of the day, my time, Colorado, Mountain Time. But I do plan to come back in the afternoon. So I'll schedule a second show for the afternoon to continue coverage of this trial. Nothing I can do about the schedule, unfortunately. So what else do we need to talk about? General overview of this case is that it was July 30th, 2022. So pretty quick to trial, actually. Nicolae Miu got into a confrontation with several other tubers. They were all tubing on the Apple River in Wisconsin. He would end up stabbing 5 people, one of them fatally, 17-year-old Isaac Shuman. So he's charged with first-degree intentional homicide for the death of Shuman, who was 17 years old at the time. Nicolae Miu is 54. And he's charged with multiple counts of attempted first-degree intentional murder for his stabbings of the other, I believe it was another 4 people. And of course, his legal defense is self-defense, with some interesting twists that we'll be talking about before we dive into the opening statements of this class, of this trial. So with that out of the way, I'll dive into the formal launch of today's show. If you are watching this on YouTube, a thumbs up and a subscribe is always appreciated. If you're watching this, if you're a Law of Self-Defense member and watching this on the member live stream, you may need to refresh the page. We only updated the live stream page to today's content shortly before we launched the show because we did this in kind of a rushed manner. All right. With that out of the way, let's go ahead and launch the formal start of today's show. And, of course, our sponsor. Today's show is brought to us by none other than Law of Self-Defense itself in the form of our upcoming Law of Self-Defense Advanced class. This is our full-day class. We only teach twice a year. That teaches you everything you need to know to be hard to convict if you're ever compelled to use force in defense of yourself, your family, your property, all in one day, Saturday, April 20th. We only teach this class twice a year, folks. So if you miss this one, it'll be October until we do it again. Can you afford to wait? Do you know when you're going to be attacked? When you'll be compelled to defend yourself, your family, your property? You don't know. It's up to the bad guy to decide that. He chooses the time, place, and manner of attack, not you. You need to have this insight, expertise on board before the attack happens. So it's available to you in the crisis of the moment. The only way to do that is make sure you learn it now. And this next class is Saturday, April 20th. And if you register now, you can get up to 50% off the normal registration fee. Learn more about that at lawofselfdefense.com/advanced. What do we cover? We cover the 5 elements of self-defense, which I'll be going through in some detail, talking about the Apple River stabbing case in just a moment. Innocence, imminence, proportionality, avoidance, and reasonableness. We talk about defense of yourself, defense of others, family, friends, strangers. We talk about defense of highly defensible property like your home and least defensible property like your stuff and your pets. We spend almost an hour talking about interacting with the police in the aftermath of a use of force event. We spend a lot of time talking about how you can devise a legally sound self-defense strategy that not only helps you win the legal fight, but makes you more decisive and effective in the physical fight as well, and much, much more, all in one day. lawofselfdefense.com/advanced. And if you have a conflict on that Saturday, April 20th date, I would encourage you to register anyway, because we will make the recording of the class available to all the registered students for a 2-week period after the class, so you can watch it at your leisure over that 2-week period. After that, again, the soonest we'll schedule the next one is at least 6 months out, which would be October of 2024. Do not wait. Sign up now, 50% off. Make yourself hard to convict. lawofselfdefense.com/advanced. So we have this Apple River stabbing event where defendant Miu was tubing down the river, apparently, purportedly looking for a dropped cell phone using some snorkeling gear, got into a confrontation with a group of other tubers. The confrontation turned violent. There was pushing, shoving, and Miu came up with a knife in his hand and started stabbing people, one of them fatally. I have a couple little cell phone video clips to share with you. One of them does highlight a knife to the belly. That person did live, ended up with a very ugly scar. So fair warning, this is a trial about a violent act. This show's already been demonetized on YouTube. Thanks, YouTube. Always appreciated. So fair warning about that. That's what we'll be, that's the nature of the case we'll be covering today. So let me share a couple of those videos with you. I'll share the first one at least right now. And then we'll talk about some of the legal issues we can expect to come up in this case. So the first video I have to share has been around for quite some time. It's hard to see much in this one, but it's what we have to work with. And as we go through the trial, we'll have some more detailed, close-up, focused cell phone video as well. But let me play this for all of you just to provide some initial context on this event. Here we go.
What is he on? Whoa!
So the guy with the big belly is the defendant, Nicolae Miu.
Where's your way? Oh, God! Yeah! What are you talking about? What the hell are you talking about? Get away from us! What? What's going on with y'all homie? He's on camera. Tripping. He's on 4K. Yo, the new iPhone got that good quality. What do you say? Yeah, what the hell? Who is this? Yes. For the culture. Who is that? For the culture. Who is that? Who the hell is this?
Bro, it doesn't matter.
He said he was looking for little girl. He said he was looking for little girl.
You're looking for little girl.
Yeah.
That's exactly what he said.
Weird us out. I didn't have that part on camera. Did I?
Some young ass kid.
What the hell is this guy's problem, bro? We're trying to have fun. Is he gonna claim you? He's gonna claim you. We don't want this one. That is on camera. Oh, God, He ain't a woman. He ain't a woman. You ain't a woman. He ain't a woman. You got him. What the fuck? What the fuck? What the fuck? He's dying! He's dying, bro! What? Oh my god! Oh my god! Oh my god! Are you serious? Is this real? Oh my god! Who is that? Oh my god! Oh my god! Is this real? Is this real? Oh my god! Oh my god! What the fuck? Is this real? Like, that's not Bart! That's not Bart! That's not Bart! That's not Bart! That's not Isaac! Oh my god! Oh my god! This isn't real! This isn't real!
It was pretty real. Isaac, the name referenced there, is actually the victim who died in this event. And as unlikely, as common actually in knife attacks, quite different than gun attacks. So a gun attack, a gunfight, I should say, there's really no delay between the use of the gun and the awareness of everybody around that deadly force is at play. In knife fights, it's quite common for there to be a substantial delay between the use of the deadly force, the use of the knife, and people's awareness that deadly force is at play. Often when people are stabbed, the effects are delayed, but also often when people are stabbed, they don't know they're being stabbed. It feels just like a punch to them. So unless they see the knife, they may feel just like they're being punched, not be aware that they could potentially have been mortally wounded. We see that kind of delay here. So if I rewind this, well, I don't want it to play again. One of the people who was stabbed, and we'll have a close-up of this, is wearing bright yellow bathing suit. I'm going backwards through the video now. Where was he? Right there. He's been stabbed. He's on his back here. He's very seriously stabbed. We'll see during the trial, the scar left on his belly is maybe a foot long. So very serious. But I'm going backwards again. The point at which he was stabbed, by the way, there we can see the defendant with the knife in his right hand. And the actual stabbing occurs see, he's about to bring the knife up, or he's already brought it up. He's already stabbed right there. That's when the person in the yellow gets stabbed. That's at 1:55. And then we see him on his back floating in the river at 2:09. So about 15 seconds later. And it's only now that bystanders are beginning to realize that people have been seriously, in one case, fatally stabbed. All right. So Nicolae Miu is claiming self-defense for his use of force here. What's required for a claim of self-defense to be valid here? Well, it's the usual 5 elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. These are the building blocks of any claim of self-defense. Now, these are 5 elements. The good news is only up to these 5 elements are required for a use of force to be lawful self-defense. There's not 500 elements. There's not 50 that you have to remember. There's only 5, and sometimes not even all 5. For example, the element of avoidance has to do with whether or not there's a legal duty to retreat. Wisconsin is a stand your ground state. There is no legal duty to retreat in Wisconsin before you can otherwise lawfully defend yourself. So effectively, then there's really only 4 elements. Although avoidance can be brought back in if you were the provoker of the confrontation, which I'm sure will be a legal issue in this case. So you can reacquire a legal duty to retreat. Also, Wisconsin is a soft stand your ground state, meaning that although there's no legal duty to retreat, you don't automatically lose self-defense because of a failure to retreat. The state is free to talk about the fact that if you had an opportunity to retreat and a reasonable person would have taken advantage of it, your failure to take advantage of that safe avenue of retreat made your conduct unreasonable. And of course, reasonableness is its own independent element of self-defense. If your use of force was unreasonable, you failed the reasonableness element. That's a required element of self-defense. You lose self-defense. Now, all these elements are points of attack for a prosecutor because they are cumulative. Cumulative, meaning all the required elements are obviously required. If anyone is missing, whatever your use of force was, it cannot have been self-defense. Now, it may have been imperfect self-defense, and we'll talk more about that in a moment, but it cannot have been perfect self-defense. Perfect self-defense is what gets you to an acquittal. When it's perfect self-defense, your use of force was simply not a crime. Now, of course, self-defense is an affirmative defense, meaning that you're not saying it wasn't you, someone else did it, you have an alibi. You're saying the opposite of that. You're saying it was you. You did this. You used force against this person and caused them injury, caused them death, whatever the case may be. But you had the legal justification of self-defense. So what an affirmative defense is saying is it's a defense of confession and avoidance. You're confessing not to a crime, but you're confessing to the underlying physical conduct that is the basis for the criminal charge against you, in this case, murder. But you're seeking to avoid criminal liability based on a legal justification, in this case, self-defense. So those 5 elements. Let's step through them quickly. So innocence, the first of the 5, has to do with you not being the initial aggressor in the confrontation. And Wisconsin law defines initial aggressor pretty broadly. It doesn't necessarily have to be criminal aggression. It could be conduct that you would have a reasonable expectation would lead to a confrontation. Fighting words, for example, could be enough. If you're the initial aggressor in the confrontation, the first person to threaten or use force or to provoke the use of force against you, you lose the element of innocence, you lose self-defense. Now, it is possible to regain self-defense, even if you were the initial aggressor, and you can do that under 2 circumstances. One is by withdrawal and communication. You withdraw from the fight, and you communicate that you no longer wish to fight. Now, for the fight to continue, the other party has to come to you. And that essentially starts a second fight in which they are the initial aggressor and you've regained the element of innocence for purposes of self-defense. Another way you can regain innocence, even if you were the provoker, is if what you provoked was a non-deadly force confrontation and the other party responds with unlawful deadly force. If you start a non-deadly force confrontation, the other party is privileged to respond with non-deadly force and lawful self-defense. But if they unlawfully escalate to deadly force in response to your non-deadly force threat, again, that effectively starts a second fight, a deadly force fight in which they are the deadly force aggressor and you've regained the element of innocence for purposes of self-defense. Now, there is a form of provocation where you cannot regain innocence under Wisconsin law and some other states, and that is called provocation with intent. So if you provoke a fight with the intent of having an excuse to use deadly force against that other party, then you cannot regain self-defense by withdrawal and communication. You simply own that fight forever for the duration of the fight. And this, for example, might be the person who says, go ahead, throw the first punch, I dare you. It's not because they want to be punched in the face. It's so they want you to throw the first punch so it looks like they have a legal justification for using force against you. The law doesn't like that because it appears that you're attempting to game the system, to wrongfully use the laws of self-defense to unjustly claim legal privilege for using force against that other person. So they punish what they consider an aggravated form of provocation with intent by denying you the ability to regain self-defense. Yes, and this came up in the mattress trial, right? The mattress dumpster trial. The father and son confronts the big steroid guy dumping the mattress. And the father continuously says, take your swing. The guy takes a swing and the father and son shoot him. Now, the father was convicted. The son was not. Why? Well, the son did not engage in provocation with intent. He never said that provocative language to the other party. The father did. So the son had a credible narrative of self-defense and defense of others. The father just completely undermined his own justification by having been a provoker with intent. So that's the element of innocence. Next element, Imminence, the threat you're defending yourself has to be something that's actually occurring or immediately about to occur. Now, whereas innocence is going to be a big issue in dispute in this trial because of matters like, did the defendant provoke the confrontation? If he did provoke the confrontation, did he have the option to withdraw from the fight and regain his innocence? If he did provoke the confrontation, did the other parties respond by a use of deadly force against his threat of non-deadly force? And if so, were they then the unlawful deadly force aggressors in a second fight in which he'd be justified in using deadly force, the knife, to defend himself? So there'll be a lot of contention around the element of innocence in this trial. Imminence, probably not so much. I mean, the fight was ongoing. So there's no question that there was a delay in response to a threat, or someone left and came back, for example. So I don't expect imminence to be a big issue here. Proportionality will be an issue for sure, because ultimately the defendant used deadly force in self-defense. And proportionality has to do with the notion that the amount of force you use in self-defense is effectively determined by the amount of force you're being threatened with. So if you're only being threatened with non-deadly force, like a shove, you can only use non-deadly force in self-defense. You can't use deadly force in self-defense unless you're being threatened with a deadly force threat. Now, what would be deadly force in self-defense? Well, if you're using a weapon in a manner to cause death or serious bodily injury, that would be deadly force self-defense. So you'd need to be able to show that you were facing a deadly force threat. Does that mean the threat has to have a weapon too? No. The question would be, was the threat I was facing one likely to cause me death or serious bodily injury? There's lots of ways to get there with a positive answer. One way could be disparity of numbers, which we certainly have here. Another way is we have an environment here where there's weapons that are not things that were designed to be implements that are weapons. For example, just the water itself. So if there's 2 or 3 people holding your head underwater, are they inflicting death or serious bodily injury upon you? Of course they are. They're drowning you. So that would be a use of deadly force by those persons, even though they're not striking you or stabbing you or shooting you. They're using force in such a manner that it's likely to cause death or personal serious bodily injury. That would be a deadly force threat against which you could use deadly force in self-defense, assuming, of course, the other elements of self-defense are also satisfied. Avoidance has to do with whether or not there's a legal duty to retreat before you can use deadly force in self-defense. It only applies if retreat is safely possible. So even if this were a duty to retreat jurisdiction, and there's only 11 of those, that's very much the minority position in the US. Even if this were a duty to retreat jurisdiction, we'd have to ask, well, would this defendant have had a completely safe avenue of retreat under these circumstances? And the question of retreat is not at any point in the confrontation did he have an opportunity to retreat, because that always exists, right? We could always kind of wander away unless it's an absolute ambush scenario. The question is, at the moment you have to make the decision to use defensive force, at that moment, did you have a legal duty to retreat? And if safe retreat's not possible, then even in a duty to retreat state, it would not be a legal duty. You can't have a legal duty for something that's impossible for you to do. In any case, Wisconsin is not a duty to retreat state. It's a stand your ground state. I'll show you that law in a bit. There is no legal duty in Wisconsin to retreat before you can use deadly force in self-defense. Having said that, it's a soft stand your ground state. So in a hard stand your ground state, and there's about 13 of those, in a hard stand your ground state, the jury's not even allowed to consider the possibility of retreat in evaluating your claim of self-defense. In those states, the element of avoidance is completely off the table, assuming it was an otherwise lawful case of self-defense. The majority of stand your ground states, however, are soft stand your ground states. And in those states, you don't have a legal duty to retreat before you can use deadly force in self-defense, but the jury's allowed to consider whether or not retreat was possible and whether or not a reasonable person in your circumstances would have taken advantage of that safe avenue of retreat. And if a reasonable person would have, they can conclude your failure to do that was unreasonable. And reasonableness, as we'll see in just a moment, is an independent element of self-defense. So if your conduct is deemed unreasonable, well, then it can't have been lawful self-defense. It's kind of a backdoor way of attacking your failure to retreat through the element of reasonableness instead of through the element of avoidance. And finally, the element of reasonableness, and this will be a big one here. Reasonableness really has 2 facets. The first is, did you have a genuine, subjective, good faith belief in the need to act in self-defense as you did? And that's almost invariably the case in most what I would call good guy cases of self-defense. That the person acting in self-defense, if you ask them, put them on a lie detector, they'd say, yeah, no, I needed to defend myself. And the lie detector would say they were telling the truth. But the second facet of reasonableness is objective reasonableness, meaning would a hypothetical, reasonable, and prudent person have shared that subjective belief? What this means is the subjective belief cannot have been irrational or speculative or imaginative. It has to be a reasonable, objectively reasonable subjective belief. If a hypothetical, reasonable, and prudent person would not have shared that subjective belief, you fail objective reasonableness, you fail self-defense. And I'm sure the prosecution here will argue that even though this defendant may have subjectively believed he was facing a deadly force threat, that belief was unreasonable. And that gets us to the doctrine of imperfect self-defense. So if you have all the required elements for self-defense, it's perfect self-defense. And if the jury buys your argument of perfect self-defense, and we'll talk about the burdens of proof here in just a moment, if the jury buys the argument of self-defense, you're acquitted. You have zero criminal liability. Absolutely none. So you were charged with murder. You walk out of court a free man on the grounds of perfect self-defense. There is a doctrine called imperfect self-defense recognized by many states and recognized by Wisconsin, the relevant state here. And what imperfect self-defense says is you have all the elements for self-defense except objective reasonableness. So you have innocence, imminence, proportionality, avoidance, subjective reasonableness, subjective good faith belief in the need to act in self-defense, but that subjective belief was irrational. In that case, you can qualify for imperfect self-defense. And what imperfect self-defense does is it does not get you to an acquittal. You're charged with murder. You don't walk out of court a free man. Only perfect self-defense can do that in the self-defense context. And you lost that because you didn't have objective reasonableness. What imperfect self-defense does, if the only defect in your claim of self-defense was objective reasonableness, it mitigates what would have been a murder conviction down to a manslaughter conviction. Now, manslaughter is no fun. Manslaughter is typically good for 10 to 20 years in prison. But it's not life in prison without possibility of early release. You might be sentenced to 10 or 20 years in prison and be eligible for parole in a third of that time, depending on the state. So you might be out in 3, 4, 5, 6 years instead of life in prison. So manslaughter sucks as a conviction unless the alternative is first-degree murder. So those are all the kind of abstract elements of self-defense, the up to 5 elements of self-defense. Let's take a quick look at actual Wisconsin law now. Let's make this bigger. And excuse me, folks, still struggling with this cold. Let's see. So, Wisconsin statutes 939.48. I'll make myself a little smaller here. That's better. The first section of this actually has to do with the use of force in defense of attack in the context of highly defensible property. Let's see. We have, it defines it as dwelling, place of business. That's actually the next section. So here we have the first paragraph is essentially the privilege to use force in self-defense when you're only using non-deadly force in self-defense. So this is the non-deadly self-defense legal privilege. I'm going to slide over that because, of course, this was a deadly force self-defense. The next section is defense of highly defensible property, which Wisconsin defines as dwelling or place of business. Effectively, it creates a legal presumption that you had a reasonable fear. This looks like it's not quite formatted right. Let me refresh it. I thought I had fixed that. Well, it's fine. We're not going to address the highly defensible property provisions because we're not dealing with highly defensible property. Let's see. I'm going to go back to that first paragraph. Okay. Yeah, so this first paragraph actually covers both non-deadly and deadly force self-defense. The first sentence here is non-deadly force in self-defense. The first two sentences. A person is privileged to threaten or intentionally use force against another for the purpose of preventing or terminating what they reasonably believe to be an unlawful interference with his or her person by such other person. The defender may intentionally use only such force or threat thereof as the defender reasonably believes is necessary to prevent or terminate the interference. So what do we see in this first couple of sentences? A number of the elements, right? We see imminence, that someone's interfering with you. It's not some past interference. It's not some speculative future interference. It's something that's happening or immediately about to happen. That's the element of imminence. We see reasonableness. You have to reasonably believe it's necessary to use force. We see proportionality. You can only use such force as you reasonably believe is necessary to stop the threat against you. We don't have innocence or avoidance here. We're going to get to innocence in a moment. And this is just proportionality in the context of non-deadly force. So even within just non-deadly force, there is a spectrum of proportionality. A finger poke to the chest is different than a punch to the face. But the big difference, the big shift in proportionality comes between non-deadly force on the one hand and deadly force on the other. And that's where the next sentence comes into play. The defender may not intentionally use force which is intended or likely to cause death or great bodily harm. That's the definition of deadly force, force likely to cause death or great bodily harm, unless the defender reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. So here we have the proportionality. If you're only facing non-deadly force, you can only use non-deadly force in self-defense. You can't use deadly force in self-defense unless you are reasonably perceiving a deadly force, unlawful deadly force threat coming to you. Now, we still haven't touched on the element of innocence, and Wisconsin treats that in the context of what they call proportionality, or what they call provocation, not proportionality. Provocation affects the privilege of self-defense as follows. A person who engages in unlawful conduct of a type likely to provoke others to attack him and does provoke an attack is not entitled to claim the privilege of self-defense. So if you provoke the fight, which is a form of being the initial aggressor, right? Obviously, if you're the initial physical aggressor, that would qualify here, right? Unlawful conduct likely to provoke others to use force against you, right? In self-defense of themselves. If you're the provoker or the initial aggressor, you lose that element of innocence. You lose the element of innocence. You don't have a privilege of self-defense. But as I mentioned earlier, there's ways to regain your innocence. And this sentence continues, except when the attack which ensues, the response of force against you, is of a type causing you to engage in who engaged in the initial unlawful conduct to believe you're in imminent danger of death or great bodily harm. So what this is saying is if you start a fight with non-deadly force and they escalate to deadly force, well, then you've regained the element of innocence. That's an exception to the provocation exclusion. But what happens here, as part of a condition of you regaining innocence, is you also have to attempt to withdraw from the fight. In such a case meaning you were the initial aggressor, non-deadly force aggressor in the fight, and they responded with deadly force. In such a case, the person engaging in the initial unlawful conduct, the initial non-deadly force, you're privileged to act in self-defense, but you're not privileged to respond with deadly defensive force unless you reasonably believe you've exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm at the hand of the assailant. So you've regained now a duty to retreat. That would be part of the every other reasonable means to escape and avoid having to use deadly force against the other person. Now, notice the statute hasn't touched upon the element of avoidance yet, the legal duty to retreat yet. I'll come back to that in just a moment. You can also regain the privilege, the element of innocence lost by provocation, if in good faith you withdraw from the fight and you give adequate notice to the other party. So you started a non-deadly force fight, then you regain your senses. You back off from the fight. You say, hey, buddy, I don't want to fight anymore. Now for the fight to continue, they have to come to you. And they've started a second fight in which they are now the provoker or initial aggressor. And then we have provocation with intent, which I talked about a moment ago. A person who provokes an attack, whether by lawful or unlawful conduct, with intent to use such an attack as an excuse to cause death or great bodily harm to his or her assailant, is not entitled to claim the privilege of self-defense. Period. What doesn't follow here? What doesn't follow is that there's no ability, there's no paragraph B here. There's nothing that says if you're a provoker with intent, you can regain innocence by withdrawing in good faith and giving notice to the other party. There's no withdrawal and communication method of regaining innocence and regaining self-defense if you were a provoker with intent. Let's see. There's injury to other parties. I'm not sure we'll talk about that. Defense of a third person. That's not relevant here. Suicide prevention. That's not relevant here. Okay, so this touches upon this statute, the Wisconsin self-defense statute, touches upon most of the elements of self-defense, but not all of them, which you might find surprising. And partly that's because some of the elements of self-defense are found not in statute, but in case law. There's really two forms of law: statutory law created by the legislature and case law created by appellate courts. They're both equally valid. Neither one is weaker than the other. So it's very important when you're considering the use of force law in your state that you consider not just what's said in a statute, but also what's said by the appellate courts. In fact, a plain English reading of statutory language can be quite dangerous because statutes don't necessarily mean what they appear to mean. Statutes mean what the courts say they mean. So the legislature had some intent and purpose in how they drafted a legislation that's made into law. But statutes by themselves have no effect in the real world. They don't have any effect. They're just words on paper. They don't have any effect in the real world until those statutes are being applied by a court to real parties in a courtroom. And the court is making interpretations of that statute. And it's not uncommon for courts to interpret statutes in ways that are different than the apparent plain English reading of the statute. Sometimes they read additional conditions into a statute, or they appear to read conditions out of a statute. And the only way to know that is to have read the appellate court cases that interpret and apply that statute. A useful way of doing this without having to read all the appellate case law is to go look at the jury instructions. Jury instructions are not themselves an authoritative source of law, but they're very useful in the sense that they tend to be an amalgamation of the statutory language and how the courts want that statutory language applied. Generally, the jury instructions are created by the Supreme Court of the state, putting together panels of legal experts, prosecutors, defense attorneys, legal scholars, and they devise a set of standardized jury instructions that are supposed to be applied on a consistent basis from trial to trial. And because they do combine the statutory language and how the courts want it applied, if there's any case law that would add conditions or remove conditions from statutory language, we tend to see those reflected in the jury instructions. So let's take a look at some of the jury instructions. Here's one, jury instruction 805 for Wisconsin. Self-defense. So this is literally an instruction read to the jury by the judge at the end of the trial, explaining to the jury how to apply the law to the facts of the case as they believe those facts have been proven. The judge is the finder of law. He tells the jury what the law is and how to apply it. The jury is the finder of fact. They listen to the testimony, the evidence, and so forth, and they make determinations of what facts they believe to have been proven or not proven. Now, I should come back to the burdens here. Most of us are familiar with the concept of a burden of proof. Of course, in a criminal case, the burden of proof is on the state to prove the crime beyond a reasonable doubt, each and every element of the crime, beyond a reasonable doubt to the satisfaction of the jury. And interestingly, in a self-defense case, this also applies to the issue of self-defense, but in a negative way. So once self-defense is an issue at trial, the state not only has to prove the elements of the crime beyond a reasonable doubt, the state also has to disprove self-defense beyond a reasonable doubt. Now, they don't have to prove the entirety of self-defense. Remember, these 5 elements we talked about, they are cumulative. They're all required. If anyone is missing, there is no self-defense. So the state knows this, of course. They know they're in a self-defense case. So the state perceives every one of these elements as a target of attack. If they can effectively disprove any one of the required elements beyond a reasonable doubt, they've disproven self-defense. And this is true in all 50 states and true in Wisconsin as well. Importantly, this burden on self-defense for the state to disprove self-defense beyond a reasonable doubt, the burden of persuasion, persuading the jury on the question of self-defense, that burden of persuasion does not shift to the state until the defense has already met their burden of production. The burden of production is how you get the issue of self-defense into a courtroom in the first place. As a defendant, you don't have some automatic right to argue self-defense in trial. You have to qualify to argue self-defense. How do you qualify? By meeting your burden of production. How do you meet your burden of production? What does that mean? That means there has to be in the evidentiary record some evidence to support each of the required elements of self-defense. It doesn't have to be a lot of evidence. It can be a scintilla of evidence. It can be contested evidence. But there has to be more than 0, because remember, all a jury does is consider facts, consider evidence. If there's 0 evidence, there's nothing for the jury to consider. If there's 0 evidence, literally 0 evidence on any required element of self-defense, well, the jury can't find that element to exist in the complete absence of evidence. So there has to be some greater than 0 amount of evidence in favor of each element. If that's not the case, if there's literally 0 evidence in favor of any element of self-defense, well, then you haven't met your burden of production, and you can be denied the right to argue self-defense at trial. Or if you are allowed to argue self-defense at trial, at the end of the trial, you can be denied a self-defense jury instruction. And if the jury doesn't get a self-defense jury instruction, they can't acquit you on the grounds of self-defense. Now, it's quite possible here, I've heard that there have been a motion filed by the state to deny this defendant perfect self-defense, a perfect self-defense jury instruction, and limit him to, at best, an imperfect self-defense jury instruction. When such motions are filed, what typically a trial judge will do is say, well, listen, I'm not going to decide this issue now because evidence is developed over the course of the trial. And remember, the judge doesn't really know the evidence until he's heard it in his courtroom, typically. We'll see how the evidence develops over the course of the trial. I will allow the defense to argue self-defense. At the end of the trial, when everyone's rested, I'm going to look at the evidentiary record and make a determination then of whether the burden of production has been met. If it's been met, I'll give you the perfect self-defense jury instruction. If it hasn't, the most you can hope for is imperfect self-defense and mitigating murder down to manslaughter. I expect that's probably what will happen in this case. All right, so that's the burden. Let's get back to the jury instruction here. Self-defense is an issue in this case. The law of self-defense allows the defendant to threaten or intentionally use force against another if the defendant believed there was an actual or imminent unlawful interference with the defendant's person. So there's an unlawful interference, meaning the other party's the unlawful aggressor, and that interference is actually occurring or immediately about to occur. That's imminent. The defendant believed, and believed here is a subjective belief, the defendant believed that the amount of force he was using was necessary to prevent the interference, so that's proportionality. The defendant's belief was reasonable. That's the second half of the element of reasonableness, the objective part of reasonableness. The defendant may intentionally use force intended or likely to cause death or great bodily harm, that's now deadly defensive force, only if he reasonably believed the force used was necessary to prevent imminent death or great bodily harm. Determining whether beliefs were reasonable. A belief may be reasonable even though mistaken. And this is an important point. You don't have to be correct in self-defense. You're not required to make perfect decisions in self-defense. You're required to make reasonable decisions in self-defense. And a decision can be reasonable even if it is mistaken. In fact, this happens quite often in law enforcement context. A police officer is dealing with a suspect. The suspect presents a gun. The officer shoots the suspect. It turns out the gun was not a real gun. It was a replica or a toy. So it was not actually capable of causing the officer death or serious bodily injury. Yet the officer perceived it as a threat of death or serious bodily injury. That's why he shot and killed the suspect. Does that mean the officer doesn't have a privilege of self-defense? No. As long as the officer's perception, even though mistaken, factually mistaken, was a reasonable mistake, a reasonable person in his circumstances would also have perceived that it's a real gun, a real threat of deadly force harm. His use of deadly defensive force was reasonable, even though he was mistaken about the facts. So this could be, an issue here, right? Because the prosecution presumably will argue that there was not a deadly force threat against the defendant, and the defense will argue, well, first of all, we believe there was. He could have been drowned. There was disparity of numbers. But even if the jury doesn't believe there was a deadly force threat, that's not actually required. What's required is a reasonable, even if mistaken, perception of a deadly force threat. Continuing now, in determining whether the defendant's belief was reasonable, the standards is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the offense. The reasonableness of the defendant's belief must be determined from the standpoint of the defendant, so from his subjective perspective at the time of his defensive acts. If retreat is an issue, if provocation was an issue, we'll come back to that in a moment. The state's burden of proof. Here they're talking about the burden of persuasion. Jury instructions don't talk about the burden of production because presumptively you only get the self-defense jury instruction as a defendant if you've already met your burden of production. But they do talk about the burden of persuasion. So if you've met your burden of production, the state is instructed that the jury's instructed that the state has to prove beyond a reasonable doubt that the defendant did not act in self-defense. This is actually a big deal, right? Beyond a reasonable doubt is the highest threshold we use in the law. The law never requires certainty, but beyond a reasonable doubt is the highest margin. Now, a very common margin used, particularly in civil law, is preponderance of the evidence. If you're involved in a civil suit, typically one party or the other wins if the jury believes they're 51% correct. Beyond a reasonable doubt, it's more like 90%, 95%, so a much higher threshold. And of course, the state has to prove you guilty of the crime by, let's call it 95%. And they also have to disprove self-defense by, let's call it 95%. Now, not the entirety of self-defense. Remember, just any one element of self-defense is sufficient to disprove the entirety of self-defense. Of course, in a self-defense case, the first half of that problem for the state proving the crime is pretty straightforward, right? We talked earlier about self-defense being a legal defense of confession and avoidance. So you're not saying it wasn't you. You're not saying you didn't shoot or stab that person. You're saying the opposite of that. I did shoot him. I did stab him. Well, you're effectively confessing to the underlying crime. And now you're seeking to avoid legal liability through your legal justification of self-defense. So although technically the state has to prove the crime and disprove self-defense, I mean, really, you're giving them the crime, or at least the underlying physical conduct that is the crime. And the state really just has to disprove your claim of self-defense. Let's see. So the jury decision, if you're satisfied beyond a reasonable doubt that all the elements have been proved of the crime and that the defendant did not act lawfully in self-defense, you should find him guilty. If you're not so satisfied, you should find the defendant not guilty. Then we get the provocation, separate jury instruction. We already talked about this in the statute, so I'm not going to read it word for word, but basically if you provoke the fight, you can regain your innocence by withdrawal and communication. You can regain your innocence under circumstances of escalation where your provocation was only non-deadly force and the other party responds by escalating unlawfully to deadly force. But if you provoke with intent, you've permanently lost your element of innocence and lost self-defense for the purposes of that confrontation. And then retreat. This is where we get to the element of retreat. in Wisconsin law in the context of self-defense. There is no duty to retreat. So that's it. Wisconsin is a stand your ground state. There is no legal duty to retreat, but it is a soft stand your ground state. However, in determining, the jury determining whether the defendant reasonably believed the amount of force used was necessary to prevent the attack upon him, you may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. So if the defendant knew he had a safe avenue to retreat and didn't take advantage of it, well, that goes to the reasonableness of his use of force. And if his use of force was unreasonable, you lose the element of reasonableness, you lose self-defense. And a little bit on imperfect self-defense. This is from a recent Wisconsin Supreme Court decision. I just carved out the part that talks about perfect and imperfect self-defense. Perfect self-defense is what we've been talking about this whole time, the elements of self-defense. The statutes in Wisconsin define two types of self-defense, perfect and imperfect. Imperfect self-defense is an affirmative defense to first-degree intentional homicide. Imperfect self-defense is an affirmative defense to first-degree intentional homicide. So is perfect self-defense, of course. Imperfect self-defense is aptly named because when successful, it doesn't get to an acquittal, but it reduces a charge of first-degree intentional homicide to second-degree intentional homicide, and therefore does not function as a complete or perfect defense to the homicide charge. And you'll notice that the self-defense statute doesn't talk about imperfect self-defense at all. So where do we get this imperfect self-defense from? Well, it's actually embedded in the homicide statute for Wisconsin. So here it is, 940.01, first-degree intentional homicide. Whoever causes the death of another human being with intent to kill that person is guilty of first-degree homicide, Class A felony. That's the charge against this defendant. But there can be mitigating circumstances. One is adequate provocation. This is where the killing's committed in what would be called hot blood rather than cold blood. Often it's in the context of a fight, which of course would potentially apply here. This would be a lesser included offense of the first-degree homicide charge against this defendant. But in terms of imperfect self-defense, they don't use the words imperfect self-defense in the statute, but this is what they're talking about. Unnecessary defensive force, where death was caused because the defender believed he was in imminent danger of death or great bodily harm and that the force used was necessary, but either belief was unreasonable. That mitigates the first-degree murder to second-degree murder. All right, so do I have any more to say about all of that? I think it's time to get into the opening statement. So, a little bit on the parties involved. Let's see. So, defendant Nicolae Miu, 54 years old. The victim who was killed, Isaac Shuman. That's the basis for the first-degree murder charge here. But 4 other people were stabbed. So there's additional counts of attempted first-degree murder. Stabbing occurred July 30th, 2022. So not a year ago. Almost 2 years ago. On the Apple River. The judge is Judge Michael Waterman. The prosecutor is a 2-person team, Carl Anderson and Bryant Smedstad. I believe Carl Anderson is the elected district attorney in this jurisdiction. Elected DAs generally rarely try cases themselves, but of course, this is a very high-profile case. The defense, Aaron Nelson and Corey Tarafasi. Remember Corey Tarafasi? One of the co-counsel, not the lead counsel, but one of the co-counsel, the second chair in the Kyle Rittenhouse trial. Aaron Nelson, I believe, is lead counsel here and will deliver the opening statement for the defense. Okay, so now that I've said all that, I'm going to jump in here. This is from Monday, so we're several days wound back. The judge has just read the jury a bunch of preliminary jury instructions. I'm not going to go through those. We read most of that law here, most of the substantive law here, and now we're going to start for our purposes, jumping right into the start of the state's opening statement. So here we go with that. As usual, in court, the audio is not great, folks, so I'll boost the audio as much as I can on my end.
Mr. Anderson.
Thank you, Judge.
This is Carl Anderson.
Do you want that picture?
Corey Tarafisi did a very, very good job in the Rittenhouse trial. Let's see. I'm blanking on the name of the lead counsel. Very, very notable guy. Mark Richards, and Natalie Wisco was also involved in that case. I've encountered Natalie as kind of co-guests on various LawTuber streams. Very smart, very capable, and I believe she's has a lead role in the appeal for the Anderson appeal, the Zach Anderson appeal, taking place now, which we've been covering his trial earlier this week.
Senseless and horrific acts of violence.
Senseless and horrific acts of violence. By the way, folks, I'm going to try to play it back at a high 1.25 speed. I say that explicitly so you don't think that's how these people actually talk. If it's too fast to understand, I'll lower it back down, but just in the interest of time.
When all Nicolae had to do was walk away. That's what you're going to see in this case. You'll see he eventually did walk away, but not until after stabbing 5 people. As Judge Waterman said, my name is Carl Anderson. My co-counsel, Brian Smestad, and I represent the state of Wisconsin in this case. It's our duty to prove beyond a reasonable doubt that Nicolae Miu is guilty of all charges. You're going to hear in this trial that Nicolae said it was self-defense. But there's a video of what happened. You're going to see the video. You're going to see the sequence of events. You're going to hear a lot in the video. You're going to hear people yelling at Nicolae over 20 times, some version of "get away, go away." You hear the boys, the teenagers yelling, get away from us, get the fuck away, get back, get away from us, walk away, walk away. You're going to hear that there's another group of tubers, adults, who hear this and come over to help the boys. You're going to hear them yelling, go, get your ass and go, get your ass and go, go. You're going to hear that Isaac's group and the group of adult tubers, I'll probably refer to them as the Carlson group throughout the trial, didn't know each other, still don't know each other. You're going to hear from both of those groups testify about what they saw. You're going to hear that there's 6 victims in this case, 1 that was punched, 5 that were stabbed, and you're going to hear from all those victims except Isaac Shuman. That's because on July 30th of 2022, Nicolae Miu killed him. It was the summer before Isaac's senior year of high school. He was living in Stillwater, Minnesota with his mom, stepdad, brother, and stepsister. He was looking forward to going to college after high school. The photo on his left is his last school photo from his junior year of high school. The photo in the middle was his last birthday. He went out to celebrate at a restaurant with his family when he turned 17. The photo on the right, he was showing off the new trailer he bought to his mom for his new car detailing business. On July 30th, 2022, it was a nice day. Weather was in the 80s, perfect sunny day for tubing. You'll see body cam that it was busy. There was a lot of tubers on the river. Isaac was tubing with 5 of his best friends. Alex Bang, Juwan Cockfield, Owen Pelican, Ryan Nelson, Landon Weiner, and the last photo is Isaac. His friends called him Bike. These are, you'll see, this is how they're dressed when they're on the river. These are screen grabs from that day. The other group you hear a lot about is the Carlson group. The only one who was stabbed out of Isaac's group was Isaac. The rest of the people stabbed and punched were from the Carlson group. Riley Madison was stabbed. Dante Carlson was stabbed. AJ Martin was stabbed. Tony Carlson was stabbed. Madison Cohen was punched. The other group you'll hear a lot about is Nicolae Miu's group. Some of these folks you'll hear more about than others, likely. Ariel, you'll see him in the video of the incident. Gilma, I expect you'll hear testimony from her. Eric Von Williams, you may see in some body cam, hear testimony. Nicolae Miu, that's Sandy Miu, Nicolae's wife at the time. Ernesto, you'll see in the incident video also. So Nicolae and Ernesto worked together. A lot of these other people knew Nicolae through Ernesto or just met Nicolae that day. Sergio he's the far right. He wasn't actually in this picture, but he was the last member of their group. So all these groups were tubing on the Apple River. They're all out with friends. They're all drinking. This is a map of the Apple River. Tubers started at River's Edge up on the top right, and they kind of tube in this snaky U shape down and then left and up. A lot of the tubers stopped and did stop in this case at the Hideaway. There's a bar there, there's a beach spot to hang out. The incident, the stabbings, occurred shortly before the tubers reached the 35 bridge that crosses over the river. You might hear it referred to as the Sunrise Bridge. And then the place where tubers exit is called Village Park Exit. And you'll hear that the only group of these three groups that made it to the exit was Nicolae's group. You'll hear that shortly before the incident, Ariel's phone got knocked in the water. It was in a waterproof case. You'll hear testimony that he wasn't that worried about it. He said he has insurance for his phone, but Nicolae insisted on looking for it. So the group ends up waiting at the sandbar. Nicolae goes downstream. He's got goggles and snorkel. He's going to look for the phone. Isaac's group is tubing a ways downstream. And you'll hear them describe that this older guy is tubing next to their tubes in extremely shallow water, getting really close to them, not really saying anything. He's got we'll describe a strange look in his face. They're creeped out by him. You'll hear from several of them that he said something about looking for little girls. You'll hear from one or two that he said something about looking for a phone. Juwan, second from the left, filmed the main video in this case. He also filmed a 9-second video shortly before that main video. And in that 9-second video, you'll see Juwan saying, he said he's looking for little girls, he's a raper. And Nicolae is walking away. He doesn't keep walking away. At the end of that video, he stops and he turns around. 2 seconds later is when that main video starts. The video of the stabbings. You'll see at that start of the main video, Nicolae is walking towards the group of tubers. They're down in their tubes, the teenage boys, Isaac's group. In the beginning, when Nicolae is walking towards him, he's got his hand down on a pocket at the right of his shorts. You'll hear from people from his group that that's where he kept his knife. You'll see in the video that he then starts to run. He runs at the boys who are down in their tubes. That's the only time in this video you'll see Nicolae run, when he runs up on the group of teenage boys. He doesn't even run after stabbing 5 people. He walks away. There's his hand on my pocket. He's carrying his snorkel and goggles. That group in the background there, in the middle photo, that's the Carlson's group. And eventually come over in response to the yells of the kids. Nicolae puts his goggles in his mouth and grabs onto their tubes with 2 hands. You'll hear in the video the boys are yelling, "Whoa, whoa, what's this guy doing, weirdo?" You can see their reactions in the video. That's Alex Vang on the left. Nicolae drops his goggles and snorkel in the water. And then starts reaching in the water where they fall into the water. Starts walking around their tubes. They're yelling at him, get away from us, walk away." They're also chirping at him. You'll hear Juwan saying, "He's a pedophile." Nicolae says something back. You can't hear it in the video. He's standing, now this is facing downriver. So the direction they're tubing, that's that bridge going with the river in the background. Boys are yelling, "Get away." That's Isaac in the middle photo with the white half, purple chunks. It's Isaac again on the left photo, standing with his hands up, fingers splayed. You see a gold bracelet on his left wrist. You see that again later in the video. At this point in the video, you hear the boys start to cheer. And that's because you'll hear from them that the Carlsons, some adults, were coming over to help. Those 2 people you see walking over are Madison and Dante. Madison's later punched, Dante's later stabbed. There's Isaac's bracelet. As Madison is walking over, she's yelling, "Go, go, go." Nicolae says, you'll hear it in the video, "They took my snorkel." Madison's pointing and yelling for him to go. You can see in that pocket on his shorts, a metallic clip with his pocket knife. Madison's pointing and yelling at him to go. Nicolae turns his back to her, looks back at the group of boys in the right photo. She drags him back away from the boys, back to her. We hear from her, that's why she went over them in the first place, was to try to get him away from the boys. She keeps telling him to go. He starts smiling. He waves upstream towards his group. More women from the Carlson group come over. That's Riley in the middle, in that middle photo. She ends up getting stabbed. Right photo, you can see Nicolae puts his hand on that knife in his pocket again. He's smiling. The boys are laughing. They're drunk 17-year-old boys. They have nothing in their hands, as you'll see in the video. They're laughing and pointing at Nicolae. He's smiling. Then you'll see his hands start moving. You can't quite see what they're doing. You can see they come together in front of his waist. You can see behind him, there's nothing but clear and empty water. As Madison and Riley, 2 women, are talking to him, telling him to leave, he takes out his knife. He opens it, blade up, still smirking, looking straight at the women. You'll not see Nicolae raise his knife and brandish it. You'll not hear him yell at anyone to get back. You'll not see him say anything at this point in the video after he takes his knife out. You'll not see him try to take a step back or walk away. You will see him looking around, smirking, while continuing to hold the knife down by his side. While holding the knife, he looks around, looks back over at the boys. You can see Riley leaning over, trying to keep his attention. Nothing but clear water behind him. You'll see Madison's got sunglasses on. Some more people from the Carlson group come over. That's AJ in the yellow swim trunks. He gets ultimately stabbed, you'll see. That's Dante in the right photo. He gets stabbed. This entire video is 3 minutes and 23 seconds long. It's not a very long video, but from the point in the video when witnesses say Nicolae punched Madison until you see Nicolae walking off after having stabbed 5 people is only about 20 to 25 seconds. It happens very fast in the video. You'll see that when you see it played in real time. You'll see the boys are loud. They're boisterous. You'll hear that in the video. There's a lot of yelling. Pedophile is looking for little girls. Go, get away from us. You'll not hear anyone in the video threaten Nicolae. You'll not see anyone raising fists to him before it turns physical. You won't see anyone besides Nicolae with a weapon. You won't see the boys touch Nicolae until after stabbings start. The next portions of the still frames is moments before the witnesses say it turned physical when Nicolae punched Madison in the face, who was one of the women standing in front of him. The Carlsons say he punched Madison. The boys, the teenagers, say he punched the blonde girl. They didn't know her name, they didn't know each other. It happens fast. Remember, up to this point, Nicolae already has the knife in his hand. After it pans, from the last frames I showed you, AJ was walking over in the yellow swim trunks. The video pans back to the middle. You see Madison and Riley are standing in front of Nicolae. The video pans to the left. You see the boys still laughing. That's Isaac in the background of the middle photo. He's pretty much just standing there in the background. Then you see everybody react, and you hear it. You hear the change in the tone. And this is when witnesses say Nicolae punched Madison in the face. You hear Madison testify, and Nicolae punched her in the face. Madison's sunglasses are no longer on her head. You hear testify that they got knocked off when he hit her. After Nicolae punches Madison, Dante, her friend, punches Nicolae. You can see that in the right frame. Again, Madison's sunglasses no longer there. Nicolae goes down in the water. You can see in the right photo, he gets slapped. Shallow water, his butt's in the water, essentially. That's AJ in those photos, pushing on Nicolae's back. You'll see that the push doesn't really do anything. Nicolae gets right up with the knife in his right hand, lunges at AJ as AJ's going to push him again. As AJ is pushing Nicolae, Nicolae stabs into his lower abdomen with the blade up, slices out his stomach. You can see in that right photo, he just missed his throat, chin. In the middle photo, you can see AJ's stomach opened up on the bottom, right above the swim trunks. From the push from AJ, Nicolae goes down, lands in his butt in the water again. You won't see anyone in the video pounce on him at this point or approach him, try to hit him when he's down in the water. You see him try to grab at Tony. It's Tony, you'll hear that's Tony in the jean shorts. Tony walks by him. Tony has his back to Nicolae. And you'll hear Tony yelling in the video, "Get back, get back." You hear testimony from Tony that he thought he was breaking up a fist fight. So he's yelling at somebody off screen to get back. He has his back to Nicolae. Nicolae gets up, still with the knife in his hand. That person in the top left of the left photo is Riley. So after Tony, you hear him yelling, directing somebody off screen to get back. He turns to Nicolae and he's yelling, "Get back, get back." And you see him pointing in the video and yelling. And you see Nicolae's hand going back with the knife in it. He makes a stabbing motion off screen. Tony's yelling at him, "Get back." And then you see Riley's just been stabbed. That group in the background there that Nicolae's facing with nobody between him and that group is his group. That's his group of tubers. Tony, you'll see, you hear from him when he testifies that he's just yelling at Nicolae to go. Nicolae doesn't. Again, that's his group. In the right photo, the guy with the aviators, that's his friend Ariel, almost up to Nicolae. Nicolae doesn't walk back to his group. Instead, he turns to Tony. With the knife in his right hand, he stabs at him twice. You can see Riley bleeding in the background. Ariel, Nicolae's friend, is there as he's lunging the knife at Tony. That hand there on the bottom right-hand corner, you'll see it more clearly in the next still shots. Isaac goes to shove Nicolae. See the gold bracelet? As he's shoving Nicolae lunges out with the knife. Nicolae kind of stumbles back from the push, comes back with his knife covered in blood and dripping blood. You can see the women recoiling from him. Nicolae ends up by his friend Ariel as he's stumbling from the push. You don't see Dante get stabbed in the video, but I expect you'll see evidence and testimony that it was after this. It's not until this point in the video, after he stabbed AJ, Riley, Tony, and Isaac, that you hear people start react and realize what's going on in the video. You hear that they all suddenly saw AJ, and you'll see in a second what they saw. Up until that point, people didn't realize that Nicolae was stabbing people. You'll hear in the video the shock and disbelief as what just happened. Camera pans around, you see Nicolae looking in the direction to where AJ and Isaac are. AJ is in the water, holding in his guts. Isaac's friends scatter and run. Juan, who's filming, runs back. Nicolae walks away. You can see at this point, if you recall the photo of Dante, he's got dark chunks on the bottom, light on top. He's got his hands on his torso and he's looking down. Nicolae continues to walk away. He walks by his friend Ariel. On that right photo, he's standing in front of Ernesto. He walks by Ernesto. On the right there, that's Alex Bing running to Isaac, who is collapsed in the water. You see AJ struggling. That's Nicolae by Ernesto. Nicolae continues walking. The camera pans away, and it pans back. Nicolae's off in the distance. Pans down a little bit, and that's what the middle photo is showing. And then you see in the left photo, you see he's approaching the right shore. Camera pans down, pans back up, and he's walking away from the right shore. Isaac's group and the Carlson's group start helping each other, try to get to shore, get the victims to shore. Isaac and AJ, who are collapsed. Nicolae starts walking back from the right, over across to where his group is at the sandbar. Camera pans around the water. Water's running red. It's Isaac's hat floating by. Nicolae is almost back to his group. You can see people trying to help AJ and Isaac. You see a couple people from the Carlson's group start to call 911. We hear from the 4 people that were stabbed, and none of them saw Nicolae with the knife. They didn't notice he had a knife. They didn't know. They thought they were punched until they looked down and see all the blood. There's not going to be any testimony on what Isaac saw. If he saw Tony get stabbed right in front of him when he went to shove Nicolae, because Isaac's not going to be here to tell what he saw. You hear that some Good Samaritans who are also tubing, some nurses, attended to AJ and Isaac until law enforcement and paramedics arrived. AJ, as a result, was disemboweled. He had to have emergency surgery. He was in the hospital for nearly a month and had to have numerous follow-up surgeries. Riley, who was in the bikini in the middle photo, was stabbed in the side. It sliced her diaphragm. She had to have emergency surgery. Tony was stabbed twice. One will describe how he kind of blocked it. He thought it was a punch coming in, so it just kind of scratched him, but the other one went into his torso. Isaac was stabbed in the chest and the torso, cut clean through 2 ribs, and sliced his heart. Died almost immediately. He was 17 years old. Dante was also stabbed in the torso. Nicolae returned to his group. You'll hear from people in his own group. He didn't really say what happened. He said, they took my knife. They stayed at the sandbar for a while. So a little while, sometime after law enforcement arrived. Multiple members of his group called 911. He did not. They reported they didn't know what happened, but multiple people were injured. One person from the group, Eric Von Williams, went over to help with the wounded. He also spoke with law enforcement when they got to the scene. He's the only one who did. At some point, Nicolae tells his group that they should just float to the exit. So they floated to the exit. You'll see that when law enforcement arrived on the scene, it was chaotic. Information they had was that an unknown subject stabbed 5 people. People didn't know where he was. They're all looking at AJ and Isaac and trying to help each other to shore. Nobody paid attention to where the guy with the knife went. There's dozens of tubers that continue to go through. There's tubers running through the woods trying to find the guy who was stabbing people. Isaac and AJ, there's no place to get to them by road. Officers had to go to the nearest. They went to the 35 bridge and then they had to wade upstream to get to them, float them out on tubes. You'll see that when officers get there, there's bystanders, just other tubers intermixed with victims, intermixed with witnesses. Some of the witnesses were so emotional they couldn't even articulate what happened at first. So Juwan, who filmed the video, he alerts law enforcement that he's got a video of it. And he pauses it at an image of Nicolae from the video. And that deputy circulates it around to tell their law enforcement who are responding. Officers go down to the exit. One deputy walks right by Nicolae and his group because he's looking for somebody who matches that photo. The report's all that they had where he was by himself. Deputy walks right by Nicolae, but then 2 citizens, one employee of River's Edge who had the photo, and a friend of the owner of River's Edge, alerted law enforcement that they think this guy matches the photo. Nicolae is apprehended. Members of the group asked, why is he being detained? You have the wrong guy. This is how he was dressed when law enforcement made contact with him. You'll see the body cam. Nicolae doesn't really show any emotion. He was taken into custody. You'll see a video of Sheriff Knudsen. Nicolae is in the back of the squad car. Sheriff Knudsen goes to check on him. How are you doing? You doing all right? Nicolae says, what's going on? I hear somebody got stabbed. And I fit the description. Nicolae is later told by officers that he's under arrest for homicide and attempted homicide. Ultimately, Nicolae is interviewed by Lieutenant Randy Hart. In that video, you'll see the recording of that interview. His version varies drastically from the video of the incident. The interview is about 45 minutes long. We'll get to see that video, but I'll highlight some portions of it. When Nicolae is interviewed, he's not told there's a video. Lieutenant Hart shows him a screenshot, that one that went around to law enforcement. She asks if he knew that they took his picture. He says, no, I didn't know that. And then he asks if she has any other pictures of him. What other pictures did they give you of me? So up to this point, Nicolae told his group they should leave the scene of the stabbing. He put on the jacket, hat, and sunglasses. He tried to walk by law enforcement at the exit. He said to Sheriff Knudsen, I heard somebody got stabbed. He's told he was under arrest for homicide and attempted homicide. So you'll see in the video, Lieutenant Hart is explaining he doesn't need to speak with her. Nicolae responds, or I can say it was self-defense. Self-defense. There's lots of people that came to me, self-defense, and they produced 2 weapons when I took from them. And that's the only thing I tell you. They hit me, they were on top of me. I don't remember anything after that. I just remember I ran away. You'll see that Nicolae repeats over and over throughout the interview that they pulled knives on him. Because of that, he feared for his life. He also repeatedly says they knocked his goggles off his face. He says they're trying to pull his swim trunks down. And they snorkeling, so they took my snorkel away. They threw it in the water. They grabbed my pants. One wanted to pull my pants down, and I grabbed onto them. And I don't know who that kid was, but he had a knife on him, and there was another knife, a longer knife, looked like a kitchen knife. They came, they grabbed my snorkel, and they threw it in the water. His goggles are lost. They took them, they grabbed them off my face, and threw them in the water. Not only does Nicolae say repeatedly throughout the interview that they pulled knives on him, he says he did not have a knife. I feared for my life. There was the truth. And they started hitting me, pointing pointed a knife at me, and another kid pointed a knife. I thought that was it for me. So actually, I took it from one of the young kids, and I think that's when I swung back. When you watch the video, the only thing you'll see in other people's hands in that video are drinks, cell phones, and a vape pen. You'll hear testimony from both Isaac's group and the Carlson's group that none of them had knives. Nicolae again, one had it in his hand, so I took his hand and I bent it. I poked him with his own hand, and I took him from his hand, and then I swung. So I don't know who I hit. I just know that I took the knife from one of those kids. Lieutenant Hart asks, did you have a knife with you? No, no, absolutely no. Nicolae says he's telling the truth, but he does not know where his knife was. He says he had one earlier to cut the string for the tubes right at the beginning. I left it on I don't even know what I did with it. I either gave it to one of the people or I put it in my truck. To tell you the truth, I don't even know. I don't even know where it's at, to tell you the truth. Maybe one of the bags we had with us, it may have been in, I don't know, maybe I left it and put it back in the car. He says everything happened fast. He doesn't know why they attacked him. I don't even know why they took my snorkel. Don't know why they wanted to pull my pants down. I don't know why they're being so mean. Why did they want to scare me with a knife? They're scaring people on the river. It's a family-oriented river with knives, and what they did, I just grabbed the kid's knife. I didn't even know I was holding it right. I grabbed it from him because he tried to poke me with it, so I feared for my life. He says it over and over. They're pushing me, shoving, I tripped, I fell down. I got up, and that's where I saw one of the kids there, closest kid with the knife, and I grabbed it from him. Again, you'll hear he was already told he was under arrest for homicide. Nicolae asked Lieutenant Hart, so what happened? Can you tell me what happened? Lieutenant Hart says, yes, 4 people went to the hospital with injuries. Nicolae says, oh my God. Lieutenant Hart says, and 1 person died. Nicolae says, oh no. Lieutenant Hart says, I don't know their names or their genders, I don't know. Nicolae asks, is that because they fought each other? Again, you'll see this in the video of Nicolae walking off to the right shore before walking back to his group. You'll hear from Gilma Constanza, who was one of the tubers in his group, that as he walked back after the incident, he did not walk back directly to the group. He walked over to the shore across from them and threw something onto the bank. This is you'll hear from Chuck Coleman from the sheriff's office. It's a 3D rendering. This is a bird's eye view of it. These are approximate locations you'll hear on where things happened. The river in this image is flowing downstream, or down to the bottom. So the bridge would be below this image. The white dot is approximately where the boys were when Nicolae first made contact with them. They continue to drift down a little bit. The Carlson's group is that pink dot. They also continue to flow down, so at the time of the incident, they're more kind of parallel with Isaac's group. And then orange dot is the sandbar that you'll see in the video where you hear that the Nicolae's group was. That star, you'll hear that's where law enforcement found the knife. This is that knife that was found on the shore. You'll hear that this knife was sent to Wisconsin State Crime Lab, tested positive for blood. It was compared to DNA samples of the 5 people that were stabbed. It had DNA, Dante, and Isaac on it. By close of trial, you'll see that these were senseless and horrific acts of violence, and all Nicolae had to do was walk away. At the close of trial, the state will ask you to find Nicolae Miu guilty of first-degree intentional homicide of Isaac Shuman, attempted first-degree intentional homicide of Riley Madison, A.J. Martin, Dante Carlson, and Tony Carlson, battery of Madison Cohen. Thank you.
Let me check the time. Okay, I probably have time to take a quick pause here and just go over some stuff I highlighted from the defense opening. Let's see. One, he mentions they were all drinking. My sense was all the parties involved were drinking, including the 17-year-olds. Everybody's drunk. That can have a variety of implications, both favorable and unfavorable for the defense. One is if you're a defender and you're being aggressively approached by a number of people, there's a disparity of numbers, and they're drunk, people tend to act unreasonably when they're drunk. So that would escalate your perception of a possible threat here, especially given how easy it would be to drown in the river. Now, the prosecutor says, hey, the water's shallow here. At one point, they have the defendant face down towards the water, and they're shoving him towards the water. How much water you need to drown someone face down, especially if you have a bunch of people to hold them in place? Not much, right? There's all this talk about him having to walk away. He doesn't have to walk away. I mean, the whole question of retreat only comes up at the moment he's making the decision whether to imminently use force to defend himself. He's allowed on that river. They could shout at him for 20 minutes. We don't like you here, go away. They have no authority to order him away. It's not their property. He has a right to be there as much as them. He has no obligation to leave. Now, once he goes to use force, in that instant, might he be obliged to consider the reasonableness of retreat if it's safely possible? I would argue yes. That's the soft stand your ground aspect of Wisconsin law on the element of avoidance. But at that moment, when he's facing the imminent threat, when he's making the decision to defend himself, does he have a completely safe avenue of retreat? How fast can you move through water? He's 54. These kids are under 20. There's a lot of them. So I would argue that there isn't a safe avenue of retreat even then. And they're going hands-on with him at that point. How do you with complete safety retreat from a attack that's actually taking place? See, the boys were laughing. He says the boys were drunk. He takes the weapon out of his pocket well before he uses it, but he's not using it before there's an apparent imminent threat against him. The guy AJ is pushing the defendant face down in the water. The prosecution says the push doesn't do anything. Well, but you don't have to wait until you're drowned before you can defend yourself. You can defend yourself against the threat that's imminently about to happen. If they're apparently trying to push you into the water face down, that's relevant to your perception of an imminent deadly force threat. A prosecutor says no one, after they push him down, then they push him down face. So AJ is sliced in the stomach. Defendant goes down on his butt in water. No one pounces on him. No one tries to hit him. But all these people who stabbed him were stabbed because they were within arm's reach, which would also be consistent with him continuing to perceive this disparity of numbers attack. He's not chasing them down the river as they're running away. He doesn't walk away again, even though a couple of people have been stabbed now, I guess. And but again, in the midst of an attack, you don't have a duty to retreat, and it may well be not reasonable for you to attempt to retreat because you can't do it with complete safety in the midst of a fight. A lot of people, there's a delay. People didn't realize until a bit later that they were actually being stabbed. They thought they were being punched. I commented on that earlier. And in terms of the woman who was stabbed and the woman who was punched, the prosecutor wants to make a big deal out of the fact that they were women. But if there's a group acting in a coordinated manner to attack you, they're all responsible for the worst acts of the group. If two men are holding your arms and one guy's trying to stab you, they're all stabbing you. And you can use deadly force against any of them. So the fact that they were women doesn't matter if they could be reasonably perceived as an orchestrated attack by a large number of people on a single defender. The prosecutor mentions that some people in the defendant's group called 911, but he did not. Well, is he required to call 911, especially if he knows other people are calling 911? In fact, it's often advisable if you're involved in a use of force event for you not to call 911 for other people to call 911 on your behalf because of the things that you might say or not say on a 911 recording. If the purpose is to get police and medical there, and someone standing beside you is already calling 911, why would you need to call too? But having said all that, obviously the prosecutor is able and willing to talk about the fact that, oh yeah, other people were calling, but the defendant was not. Let's see. Some stuff that is not great for him is his conduct after the fight. Let's see. He gets up. I guess he's out of the river. He's up by the bridge. The police are looking for him based on that photo, and he's put on a jacket, a cap, and glasses. Well, I mean, that's not unlawful, but it could be characterized as consciousness of guilt evidence, that he's attempting to change his appearance based on what he looked like in the river, so it would be more difficult to identify him and hold him accountable legally. This is also true of when he throws a knife into the woods. Is that consistent with lawful self-defense, or is that consciousness of guilt evidence? That's tampering with evidence, right? Disposing of evidence. Even if your use of force was lawful, this is evidence that can be presented to the jury to suggest that you yourself believed it was unlawful. Otherwise, why would you do that? Then his interview with police. Of course, this is a train wreck for him. Again, I presume when we see this interview, we'll see there was no legal counsel with him. So just like we saw with the Alec Baldwin interview and the Hannah Gutierrez interview and many other interviews where suspects are Mirandized and then being interrogated by police, however politely, they bury themselves. They seriously damage. Also in the OnlyFans model case, which will be coming up, she did the same thing. Lengthy interview with the police, buried herself with her own interview. There are very few circumstances in which you should be talking to the police as a criminal suspect, and certainly not if they have Mirandized you. If they have Mirandized you, assert your rights. And there's generally no upside for you to be talking to investigators in particular without a lawyer present. And then he says a bunch of stuff in that interview that's just harmful to him. Like he says he didn't have a knife. Well, we can see throughout these photos, he had a knife clipped to his pocket the entire time. He doesn't know where the knife went. He doesn't know where it is. Some of the stuff he's misdescribing, they took my snorkel, pulled my pants down. Could that just be his perceptions of what happened? Even of mistaken, reasonable mistakes about what happened? I think so. But the knife stuff is much more difficult to explain away. These claims that he took the knife off of some other person, how would you mistake that? I mean, if someone bumps into you and their hands are on your body, around your waist, maybe you think they're trying to pull your bathing suit down. Maybe just make an honest mistake. But how do you make a mistake about taking the knife from someone? Now, just because you're making those misstatements a fact, whether intentionally or not, afterwards, doesn't mean your use of force was unlawful. Your use of force could be completely lawful. And then during your interrogation, you say a bunch of stupid shit to try to, I don't know, talk your way out of trouble, you think? But what matters for self-defense purposes is not how you might have mischaracterized your use of force later. What matters for self-defense law purposes is, based on the actual facts as they occurred, was your use of force lawful? And that's about it. Let's see. And of course, by the way, everything the state says here in opening, none of it's evidence, right? So obviously much of this will be introduced as evidence later, but particularly the prosecutor's characterizations of things are part of his narrative of guilt to the jury. It's conclusions he wants the jury to go for, but that's not evidence, his characterizations of it. That's part of his storytelling. All right, those are just the highlights I wanted to get into. Let's see. And the next we'll have the defense opening statement. And I believe this will be by lead counsel Aaron Nelson. Now, someone sent me a clip. At some point, Aaron Nelson refers to the law of self-defense. I should have made myself bigger for that whole talk. I don't think when they refer to law of self-defense, they're referring to me. This is my book, The Law of Self-Defense Principles. By the way, you can get this book for free at lawofselfdefense.com/free book. In fact, I should put a little banner up there. Right there. Lawofselfdefense.com/free book. Check it out on Amazon. 5-star rated. 1,500, 2,000 reviews, something like that. But don't buy it on Amazon. They'll charge you for the book and the shipping and handling. We only ask that you cover the cost of the shipping and handling. We'll send you the book for free. This book is your guide to being hard to convict if you're ever involved in a use of force event. This defendant ought to have read this book before he went tubing, July 30th, 2022. It would have been very helpful to him. But when defense counsel is talking about the law of self-defense, I think he's using the phrase generically to talk about Wisconsin self-defense law, and he reads a description of about a reasonable mistake still being lawful self-defense. It sounds to me like he's just reading from the Wisconsin jury instruction. I also describe reasonable mistake in that way in my book, just because it's just the way all the law just describes reasonable mistake. Most states' jury instructions look identical on this issue. So, of course, it's how I talk about it in my book about self-defense law. But just in full disclosure, I don't think he's actually talking about me. He probably doesn't know I exist, unfortunately. It would be nice if he'd read the book. That would be very helpful, I think, to bring clarity on all these specific self-defense law issues. A lot of self-defense cases I see go bad because the lawyers don't have this degree of clarity, because we're not taught this stuff in law school. There aren't a lot of good sources of legal information, inside expertise on self-defense law other than me, frankly. Okay. Let's pull this back up.
Thank you. Members of the jury, we are going to take a short recess. We'll come back at 2:10. Please take the jury out.
All right, for the jury.
All right, so a 10-minute recess. I don't know if they're going to stick to it, but I'll fast forward a little bit. Whoops. So this will be lead counsel Aaron Nelson.
Statement in the St. Croix County Courthouse in Hudson.
Nick Miu standing in the river with 13 strangers. 13 drunk, angry strangers. 13 against 1. They yelled and they screamed in order to attract a crowd. They got a crowd. They told lies to make the crowd angry. He's looking for little girls. He's looking for little girls. They layered their lies. They made them louder to make the crowd more angry. He's a predator. He's a predator. They chanted. They pulled on him. They closed the space around him. They got up in his face and they pushed him. Somebody else pushed him, and they pointed and they pushed and they pushed and they pushed. And when he put up his left hand, to block and protect himself as they're in his space, in his face, he puts up his left hand to protect himself. And then they got violent. They knocked a grown man, punched him, knocked him into the water. And when he's down in the water, they come up on him and they hit him again when he's down in the water. When he tries to get up out of the water, they attack him from the front, smack him across the front of the face, while somebody else comes from behind and starts pushing him down. In that moment, he feared for his life. And he responded in self-defense. Let me show you what they did. Dante Carlson, who had earlier come over into that group, right? His dad had sent him over to help Nick. But the crowd got Dante going, and it didn't matter. He was going to hit him. And when the opportunity arose, as Dante Carlson will tell you, he laid him out. Knocks a grown man back off of his feet, where it's not just his butt. You'll see on the video, it's his shoulder, it's his head. He goes into the water. He didn't have a measuring stick. He wasn't figuring out what the height of the water is. He went in the water because they hit him into the water. And when he's down, you'll see he's down in the water. And Dante Carlson, who punched him with his right hand, right? He was so confident. He was so confident. Had his beer in his left hand. And then he's given a beat down with his right hand. He then runs around him as Nick is falling into the water. And he's in the water. He runs around him with the beer in his hand because he knows he's got his group around him. And then he comes around and he smacks him again. You can see in the first photo, you can see the shadow of Dante's arm coming across. And you can see it hits him across the face and across the ear. That's not just a slap. That's a full hand. You'll watch the video. It knocks him down. And then when he's down in the water, you'll see A.J. Carlson, who you'll hear tells you that he came over there to mediate. But for whatever reason, maybe it's because of a crowd, maybe it's because of a mob, maybe it's some other mentality. But when this happens, he sees this old man down on the ground. He doesn't go to help him. He goes to push him from behind. And while he's pushing him from behind, look in the upper corner there. That's Dante's arm. You can see in the middle slide, that's Dante's hand smacking Miu across the front of his head. And then you'll see on the third slide, that's where he's extending through. So confident he's going to beat this old man down that he keeps the drink in his hand. That's the close-up that you can see through there. Dante Carlson hitting Nick Miu in the face while his friend attacks him from behind. You're going to need to make some choices in this case, right? Make some decisions. Some of the things that might help you to do. Let me just take a step back, all right? Who is Nick Miu? Who's the man that they wanted to beat down on the river? We're going to tell you about that. How did he get there? What made him be in the river on that day, as we saw here earlier? And we'll tell you that story. And then lastly, why did this angry mob, this pack of players, why did they attack him? And we're going to tell you that. First, who is Nick, right? Nick's 54 years old, lives in Prior Lake. He's married, right? See a photo. You'll hear from his wife, Sandy, right? She's going to be a witness. She was there with him that day. Him and a bunch of other 50-year-olds went to go have a peaceful day on the river, right? Nick grew up in Romania, right? And when he was about 15 or 16, he immigrated over here. We're not going to get really into it. Romania was not a good place to be in the 80s. Communist dictator, all kinds of other bad stuff was going on. And Nick's dad, like a lot of people in the world, wanted to have a better place for his family to grow up. So they, as political refugees, were accepted by a church in Minnesota, and they came over to Minnesota. When Nick was growing up, his first language was Romanian. Because he lived in this communist dictatorship, he also needed to learn Russian. Because he was in Europe, he also learned to speak French. Because he's a pretty smart guy, he also learned Latin. So when he was 15 and 16, he comes over to the United States, and then he picks up English as his fifth language. He can speak fluent English. He's fine. But I think it's important for you to know that's not his first language. When he graduates from high school in Minnesota, he decides he wants to go on and further his education, and he goes to school in South Dakota. He becomes a mechanical engineer, and he's worked as a mechanical engineer for years and years. Bit of a handyman, as I imagine a lot of engineers are, right? I don't think of myself as a handyman. He's a handyman, good with tools, hangs out with tools, and you'll hear from other people how he's used tools in the past. And you'll hear that as you'll hear on the tape, as he tells the police, living a peaceful, quiet life in Minnesota, never been in trouble before. Him and some of his work friends, as all of us sometimes as adults, our circle of friends tends to be people that we work with. He has a group of friends, Amanda and Ernesto. They've been down the Apple River before. In fact, they've invited him before, and he's been down the river one time before, several years earlier. So they make a plan with all of those, the group of people that we saw, right? Oh, I forgot one thing here. Nick, like a lot of people, maybe as they get older, isn't of the best health. In 2020, he had a heart attack. And he needed to have quadruple bypass open heart surgery. So these are the photos of him recovering from that. And it took him some time. And he'll tell you how that still makes him feel fragile, right? He doesn't feel as fit as he was when he was 18 or 22. So he decides to get out on the river with his friends. These are some of the friends. And as you'll see in photos, right? He's in the water that day. It's warm that day. Sometimes he's wearing his sunglasses. Sometimes he's not. Sometimes he's got a hat on. Sometimes he doesn't. Sometimes he has his shirt on. Sometimes he doesn't. This is the photo of the start, which is pretty much the exact same thing he was wearing at the end. His friends Amanda and Ernesto asked him to come along. There's a lot of other adults that are coming, right? There's none of these, there's no 20-somethings, no teenagers. They pack food in coolers. Sure, they have a couple of beers, but it's really just a time to get together with their other adults and float peacefully down the river. Nick likes to snorkel, right? So he brought his goggles and his snorkel, right? That's just kind of who Nick is. He's a bit of an explorer, a bit of a curious mind, and he brought his goggles and snorkel. And you'll see a video of him prior to this where he's just kind of laying in the water, letting the water rush over him. Well, he kind of floats there with the goggles and the snorkel, and he's looking at the bottom of the water. Probably not a lot of exciting things at the bottom of the water in Apple River, but he was there to see it if there was something there. Before he leaves, he gets a call from his friend Ernesto, because Ernesto knows Nick and knows that Nick's a bit of a handyman, and is like, hey, remember last time we had all those strings? We got all those strings. You got to cut up stuff. You got to do this. Can you bring that little pocket knife that you've got, that utility knife? I've seen you use it at my house. You've used it as a tool. Make sure you bring that because we need to cut up some of the strings. So he does. Gets back, packs that up, brings it along. And sure enough, when they get there, they have their provided strings. And the people you'll see, they tie up tubes, they tie up coolers, they tie up everything else. And he uses his pocket knife to sometimes cut things up, right? You'll also see as he's going through on the river that day that his shoes kind of fall apart, right? And you'll see that pictures of his shoes, he's got strings and he's tied them up and he continues to cut with the little pocket knife that he has to make sure that his shoes, his footwear, are something that he can have. So they float down the river, right? This is the group. You saw that photo already with Mr. Anderson showed that to them, right? And again, here he has the hat on. Here he's got the hat off. You'll see later, not surprisingly, when he goes to snorkel, he doesn't have his sunglasses on. And sometimes when he snorkeled, he had a shirt on. Other times he took it off. Here's another picture of him on the river with the group. Again, has the hat back on, depending upon what the sun is like. So, how did he get there, right? Well, as we talked about, Ariel, his friend, loses his phone, right? And whether they wanted to look for it or didn't want to look for it, I don't know how that's relevant. I don't know how his wanting to go help his friend look for his phone is any way important. You'll get to decide that. But we know at the end of the day is it's uncontested. His friend lost his phone. And as you saw in some of those photos, they have these little bags that they put him on, and they didn't know if it was going to float or if it was going to sink. But the water between him and the other two groups was downstream. So if something went into the water, it would float towards where those other two groups were. So Nick used his head and walked where he thought the phone was going to float to, and he goes looking for it, right? And then while he's looking for it, he runs into another group, right? And this is the group that we're going to talk about, two different groups, right? The first group he runs into is this group of high school, right? And you're going to hear that they're drunk. You're going to hear that they were smoking stuff. The one piece of evidence that we know for sure is that at the time of the autopsy, Isaac Shuman's blood alcohol concentration was 0.219. And if you ask his friends
Wow.
are going to say he was the most sober one in the group. So we have this group, they're drunk, they're loud, there's 6 of them, they're football players, they've run as a pack together before. You're going to hear some videos, they're quite confident group, right? And they see this man that maybe others are going to judge upon his appearance. This group of 6 see him and they start making judgments about him based upon what he looks like. He's an old man in the river with goggles and they don't like it. So they start calling him names. Right? And there's a video, you're going to hear it because they start harassing him. They start heckling him. They're basically trying to humiliate him. And Mr. Cockfield, one of the football players, he grabs his phone out and he thinks it's funny enough that he's going to record it. And you'll see that recording just before this where he says, "Grown man looking for little girls." And he thinks it's really funny. And then he screams out, "Raper!" He doesn't scream that out for his benefit of his 5 football friends that are with him. He screams it out to draw a crowd, get other people involved. Now, Mr. Miu may or may not have heard that exact thing, but he hears them yelling and he turns around and what does he see? He's looking for a phone, right? We know that. And when he turns around, he sees somebody holding up a phone. Maybe he's wrong, maybe he's mistaken about why they're holding up the phone, but he sees them holding up a phone, so he turns around to approach them because he thinks that's the phone he's looking for. I'm looking for this phone. It floated down this way. These kids are yelling. And he starts jogging towards them. As you saw, as he jogs toward them, he's an unfit 260-pound man trying to move through the water, and he picks up his feet for about 4 steps. Then he reaches his hands out to grab their tubes, and when he does so, he puts the snorkel and the goggles in his mouth. Maybe they thought it was an act of aggression. I don't really think it was. You'll get to see it and watch it. But we know nothing happens after that. Because as soon as he goes and approaches, the goggles and the snorkel drop. He loses them, and he immediately starts looking for them. That's about 5 seconds into the video. He starts looking for them, and they start yelling at him, "Get away, get away, get away." So this is the tubes, right? You as the jury, you're looking downstream this way, right? Nick is standing here in front of the tubes. He looks, he comes up, and then he walks to the other side of their tubes, and he's now on this side of their tubes, downstream from them. He's downstream because that's where he thinks the goggles and the snorkels come. Did he tell the police officer that he thought they knocked the goggles and snorkels out of his hand? Yes, he did. Is that what he believed happened? Yes, it was. Is that what really happened? No, that's not what happened. And the great thing you're going to be able to see in this case is there's a video. There's a video that we can check everybody's testimony against. And you know what? Riley Madison got it wrong. Dante Carlson got it wrong. Madison Cohen got it wrong. Anthony Carlson got it wrong. Pretty much every witness, when you compare their human memory against the video, they got it wrong. Because we're humans. We can't get it as good as the video does. So he got that wrong, but he's still nevertheless looking for his goggles. His goggles are down in the water. He's looking for it, right? He starts walking around there. There's nothing that prevents this group of football players who are screaming at him from just walking around. He's one man, maybe 2 feet wide. And you hear from there, they talk about him walking away, but they can just walk, just float on by and leave this man alone. But they stay to harass, they stay to heckle, they stay to humiliate. Because he starts walking away from them. And if you watch and you count, you watch it enough times, he takes about 10 steps away from them. And it's sometime during those 10 steps, when that group says, "You got 10 seconds. 10 seconds. That's what this group of drunk teenagers says to that old man. And he's walking away at that point. And then what you'll see when the video comes back, he walked away. They followed. They followed. They didn't go around. They went right up to him where he had walked away. Now remember, as he's walking in this direction, his group is 200 and some feet that way, 280 feet that way. This water is deeper. As he starts walking away, he gets into deeper water. He doesn't have his goggles, doesn't have his snorkel, still can't find the phone. He's getting farther away from this group. The drunken teenagers are yelling at him, and now they keep following him. Now, this video, all right, we're going to show some slides from the video. And it's super important, obviously. We're very thankful that we have it so that you will know exactly what happened. But what you got to remember is the video was taken by Juwan Cockfield. It is from Juwan Cockfield's perspective. It's from his point of view, right? It makes it obvious. And so the person that we're watching oftentimes is Nick Miu, right? But you need to know, which is obvious, that the video is not from Nick's perspective. We're not watching it from Nick's perspective. We're watching it from somebody else's perspective. And why is that important? Because the judge is going to tell you, right? It's important because at the end of the case, you'll need to determine the reasonableness of his beliefs from his point of view. You'll need to determine the reasonableness of his beliefs, not actions. You're here to determine his beliefs and the reasonableness from his point of view. So as you're watching that video, you're going to be asked at the end to be like, what would someone in Miu's position, from that standpoint, what would they feel? What would they believe? Let me just quickly read to this, right? If I can, the law of self-defense. In determining reasonableness, a belief may be reasonable even though mistaken. In determining whether Nick Miu's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in Nick's position under the circumstances that existed at the time of the alleged offense. Not 30 seconds before, not a minute before, at the time of the alleged offense. The reasonableness of Nick's beliefs must be determined from the standpoint of Nick Miu at the time of his acts, and not from the viewpoint of the jury now. So I say that to you just so you know when we're looking at the evidence, what you're going to be asked to do at the end. So they get him into this position, and this is 50 seconds into the video. He's walked 10 steps away. They come up to him and approach him and cut him off. So he walks away one time, they follow him. But Nick, right, sees, right, so he's here. He's got a group of people here, and he looks off to his left, and he sees a group of adults. There's 2 adults coming this way. Great, adults, not drunk teenagers. Adults are coming this way. He doesn't continue to engage with this. He gets and starts walking over here. He walks over to engage with the adults in the hope, as I think most of us do when we see perhaps another adult and we're dealing with a group of drunk teenagers. Maybe I can appeal to reason. These are adults. And when he walks over this way and the path down the river is wide open, those drunk teenagers follow him. Follow him over here, where he then gets confronted by Madison Cohen. And Madison Cohen is not listening. She's not there for an appeal to reason. Her immediate words are to Nick Miu in his face, go, get the fuck out, go. And you'll see Nick's reaction was kind of like, as you heard from the, look, they have my goggles, like, why are you in my face? What's going on? And you can see, they'll call it a smirk. They'll call it a smile. Look, there's 4,819 frames in that video. 4,819 frames. I have no doubt that you can pause on one of those 4,819 frames and find a photo where somebody's mouth is making a particular shape of anything at any time. Is he smirking? Is he smiling? You watch. You decide. Because he looks perplexed. He's immediately confronted, and he starts to give an explanation, and Dante Carlson tells him, it doesn't matter. Right? Appeal to reason? Nope. We're not doing that. That's kicked out the door. There is no appeal to reason at all. And while this is going on, the Carlson group, right, who sent 2 people over, also has Quentin Carlson, and he's an older guy. Madison Cohen, Dante Carlson, A.J. Martin, they're in their early 20s, which is fine. They're certainly adults, but that might be different than somebody in their 40s. Quentin Carlson, he sees what's going on, and what he says, I was worried about the group against one guy. I was worried that they were going to gang up on him and something bad was going to happen to the old guy. So I told my son Tony and Dante to go make sure they don't attack that old guy. That's not somebody looking at it from Nick's perspective, but that's somebody who can see maybe what Nick sees, hear what Nick hears, and his thought is, oh, something bad's going to happen to that old guy. So he sends over his kids. And when they come over, right, the high school group continues in what I think we now know, it's a new term, is they gaslight him. They just start making up lies in order to affect his perception of reality and everybody else's perception of reality. As soon as that group comes over, that high school group says, he's a predator. And then immediately they're like, he's looking for little girls. He's looking for little girls. There will be zero evidence there were ever little girls even anywhere near on that river. Zero. There's going to be zero evidence that he was looking for little girls. But they drum up, right? They get this crowd going. They've got the 2 people here, and they start yelling at, and then the crowd gets to be more, right? Because this is going on. It's about 113, 115 into it, where they start screaming at him. He's looking for little girls. And then you'll see as he's standing here, after he's walked away from that group, he walks over to the adults. He's kind of pointing at them like, I got my snorkel. And they confront him. And as he's standing there, he turns his back on her, and he just stands here. And as he's standing with his back turned, and the path down the river is wide open, instead of just walking on by, Madison Cohen decides she's going to put her hands on him, and she grabs him and starts pulling him. And you'll see he turns around and immediately looks to his hand and says, don't touch me. Don't put your hands on me. They don't walk away. They stand right there. The crowd, the drunk high schoolers, continue to say he's looking for little girls. Somebody says, is that what he said? And then it changes to the next lie is, we've got it on camera. We've got it on camera. You're going to see that they downloaded that phone. There ain't nothing like that on camera. There ain't nothing like that on the camera because that's not what happened. Because these drunk teenagers were gaslighting him and they're enticing a crowd. Nick stands there. He's now got people all around him, right? They're chanting at him, he's a predator, he's a predator. He's all alone. It's getting louder. He raises his left hand to his group. Like, we need some help here. Like something's going on, right? And when that happens, you'll see the camera, Juwan Cohen turns the camera to show where he's waving to. So the high school group has knowledge that Nick Miu, who's standing right here, doesn't want to go that way. Nick Miu, who's blocked right here, wants to go that way because that's where his group is, because that's where everybody looks. And you'll see on the camera, Madison Cohen, she stands and he waves. She turns and looks and sees he's got some friends. So does Madison Cohen say, yeah, why don't you just go that way? She doesn't. What she does is she reaches to her friends and says, hey, get over here. She calls in more numbers. She calls in more numbers to confront him. Because at that point, it was 8 against 1, and she wanted more. So she brought over Riley, she brought over Janelle, she brought over Gabby, and then she calls for Anthony, and then she calls for AJ. And then it's those 13 people that surround him, right? And they're standing there, and you're going to see they're all around him. They are relentless in what they're yelling and screaming. From his standpoint, this is like, what is happening? What world did I just step into in which there's this group of drunk kids, drunk teenagers who they want to say kids, I get it. But you saw those pictures. They're all bigger than Nick. Nick's smaller than he was then, right? But he hasn't grown any. He's just shrunk more, right? But he's not a big, fit guy, right? They're screaming, they're chanting, right? And at that point, yes, Nick, outnumbered 13-1, reaches in his pocket, finds his pocket knife, opens it up, and stands there with it. He doesn't brandish it, but he doesn't hide it. He's standing there with it. His belief at that point is, I don't want to use this. I don't think showing it to him is going to help. But if something happens, I don't know what's going to happen. So he's standing there with the knife. And as he's standing there with the knife, Riley Madison is right in front of him, and she pushes on him. You'll see that in the video. And then next to her, who's blocking him from his people, is Madison Cohen. She takes her right hand, and she pushes his left shoulder. He has to go back. She pushes him back. And while all this is going on, the group of drunk teenagers are screaming, chanting, yelling. The numbers are getting bigger. They come over towards him. All right? They push him again. They block his path. And this is the same. That's what it looks like. You're Miu. You're looking upriver to see where your safety is. Behind you is deeper water. You've walked in that direction before. You appealed to reason, and they said it doesn't matter. They're up in his face, right? And Madison Cohen's pushing and pointing at him, right? And Miu's standing there. He's got the knife in his right hand. He doesn't use the knife. He's standing there while they're pushing and pointing at him, right? And when he does that, all of a sudden, that's when Dante Carlson gets violent, right? He's predisposed for violence, I submit to you. That's the entire purpose of the gaslighting, of getting the crowd there, of yelling with the crowd, of getting it all jacked up, is Juwan Cohen wanted to record a viral video in which some old man was getting beat down, and he was going to get it on tape. He created that world. He put him in that world.
Object. A lot of this is argument, not summarizing.
Please focus on what you anticipate the evidence will show.
That's what the evidence is going to show, right? Dante Carlson has told you before, and he'll say it doesn't matter, right? At that moment, that's when Nick Miu raises his left hand to protect himself. He's raised it before to call for help. I think I missed it. He raised another time to call for help, a second time, and now they're crowded around him in his face. He raises his hand to protect it, and that's when they get violent, right? It's a push, not a punch. It's a push to protect himself, not a punch. The evidence. You'll watch that video. You might watch it 20 times. It's not on the video. There's no punch on the video. She's standing there yelling, and when she's standing there yelling, there are 2 people between her and Nick Miu. He's got the knife in his right hand, right? It's not on the video. There's no physical evidence. She says he punches her with his right hand. He's got the knife in his right hand. There's not a mark on her. You're going to see from John Schultz, his video, he spoke with her right then. He's right in her face. He's got a body cam. You'll get to see the body cam of her face, and she, not a blemish on it, not a mark on it. doesn't support that he punched her. Third thing, multiple evolving stories. Listen to what the witnesses say. Who really says is there a punch, and what position were they in to say it? Because here's what they said before. Quentin Carlson, he told the police, she said he was punched. She said he punched her, but they said it was a slap. So everybody else initially said it was a slap. Gabby, one of the witnesses, says he smacked her with his left hand. She's consistent with he raised his left hand. Mr. Alexander Vang, one of the high school kids, says he hit her with an open hand with his left hand. AJ, he says he saw him pull her hair, which nobody's going to say. That's just wrong. Nobody's going to say anything along those lines. Dante, the person who laid him out after he said that, spoke with the police. And initially what he said to the police is I saw Miu make a swift motion to Riley Madison. Then he says, I saw Miu make a motion towards Riley Madison. Then he says, I saw Miu make a swift motion to Riley Madison. Then he says a fourth time, swift motion, Riley Madison. I don't know what he's going to say when he comes up there now, but what he said before isn't a punch, and it wasn't to Madison Cohen. That's when the violence begins, right? They attracted the crowd. They moved in closer. Now, one of the things you're going to want to ask, and we will ask that, is when this happens, this group of 13 is around and the old man gets knocked and he's down in the ground. Listen to the video. Is there anybody in the group that says, whoa, this is out of hand? No. You'll hear when he gets knocked on the ground, the volume goes up. The cackling and the laughing goes up. And the videographer pushes people away to get in closer to document the beatdown as well as he can. This isn't somebody that's just taking a video on the side. And again, to move around, Dante Carlson is confident enough to still have the beer in his hand while this happens. Miu's response is in self-defense, right? People come at him, and he makes a quick, short jab motion. He believes he has to use the knife because he's outnumbered. AJ Martin once. Riley Madison once. Dante Carlson twice, but he only has 2 stitches. Isaac Shuman once. Dante Carlson once. When they come at him, he gives a quick jab. They back up. He doesn't lunge for them. He doesn't follow them. He doesn't recklessly swing it around. They come at him after they gave him a beat down, and he jabs up. Even Brandy Hart, I think you're going to hear from her, right? When Mr. Trofsky asked her questions, when people attacked Miu, he responded. She agrees with that. So what happens is pretty much all on video, right? At the end, the judge is going to read you that jury instruction similar to what he did about credibility. And how much of credibility is going to play a part in this trial is going to be up to you. You guys are the finders of fact. You decide what happened. But I'd submit to you, it's all on video. Pretty much know what happened because it's on video, right? So we can talk about credibility. Nick spoke with the police, right? He told them he was afraid. He told them he feared for his life. He told them he was acting in self-defense. He also told them, I don't really remember anything. And he lied to the police about the knife. He did. He lied about the knife. It was his knife. He brought it. He was outnumbered. He believed he needed to use it. The truth is, he used it because he was surrounded by that angry mob and he was afraid, right? They gave him every reason to be afraid. When their attacks stopped, he walked away. When they stopped, kept coming at him, and every one of them come at him, right? He responded like a victim of trauma response. You'll hear from witnesses in his group who will say he looked like he was in shock. He was white as a ghost. From his perspective, right? He had just been attacked by an angry mob who was trying to kill him, and he got his way, he got out of there. So as he walks back, he still has fear, right? It's not something that just goes away. That fear is deep inside of him at that point. And as he walks away, he wants nothing to do with the group that just attacked him. He wants nothing to do with the knife, and he tosses it up onto the shore. Maybe not the best decision. Maybe not how he should have responded. But he was suffering from serious shock and trauma at that time. That's what he did. It's not going to be a contested fact. He looks back to his group, right? And they'll say that he's wide-eyed, he's white as a ghost. Remember, he'd just been repeatedly hit in the head, pushed down into the water. His body continued to respond in that way. When he walked away, he knew he'd done some quick jab motions. He didn't know the extent of anyone's injuries. Did he hear them yelling? Sure. They'd been yelling for 2 minutes, screaming and yelling at him. He had been in trauma at that point. He didn't know what the yelling was about. He didn't know that anyone had died. Maybe he should have. Okay, fair enough. But in that situation, would you expect him, who'd just been attacked and responded in just short, quick jab motions, to know the extent of everyone's injuries? They go back and everyone's like waiting. Traffic on the river pretty much shuts down and they wait there. When the police come by and kind of basically move everybody along, his group moves along to the exit. He's got his hat and his sunglasses and his shirt on, just like he did at the start of the trip. Right? He's been in shock. They'll tell you he was cold. So these are the 3 things that you need to think about, right? 1, what happened? Don't think it's going to be a big mystery. It's on video. And I hope that that's helpful to you, because the facts, I don't think, are going to be very contested. 2, you are going to be asked, what did Nick believe? Right? He told the police, and he'll tell you, he feared for his life. In that moment, against that group who were violent with him and knocked him down, he feared for his life. Right? The video evidence supports this. Right? And I'd ask you rhetorically, what other reason is there? What other reason could there be? They came at him. He was in fear. He responded. The last question. Were his beliefs reasonable? I don't want to belabor the point about the law, right? Can't find it right away. But it's from his viewpoint, right? From his standpoint. The belief may be reasonable, even though mistaken. In determining whether Nick Miu's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in Nick Miu's position under the circumstances that existed at the time of the alleged offense. So what do we know that might help you to decide that, right? We know he walked away and they followed. We know he tried explaining to them and they said, it doesn't matter. We know they told lies about him to incite the crowd. We know he knows that those were lies and he was watching as this crowd gets louder and more intense and bigger. We know they cut him off from where he wanted to go back up to his wife and his friends. We know that somebody else that was watching, who was kind of like Nick, a little bit younger, about the same fitness level though. And when that person, Quentin Carlson, sees what's going on, his first thought is, there's something bad that's going to happen to that old guy. We know he was surrounded, we know he was outnumbered, and we know that this environment was ripe for violence. That's the environments they carry. And we know that Nick is fragile. He believed he was fragile. This is somebody who went through open heart surgery within a couple of years. He didn't have fitness. They attacked him, kept attacking him. They gave him every reason to believe they weren't going to stop. Were his beliefs reasonable? This is Isaac Shuman. I'm sure he was a wonderful man, wonderful human being. We're going to hear a lot about him. But in this moment, on this day, on that river, when he was drunk, he tried to strangle Nick Miu. His hands were on his throat. He was pushing up against Nick Miu. And Nick reaches out as he's falling back. That's what Nick did. His belief at the time, when he's being strangled after being constantly attacked, was he needed to get out of that. And the only way that he could do that was with his knife. He believed his life was in danger. To resubmit to you under those circumstances, that's reasonable. At the end of the trial, we're going to come back up here, right? We'll be back up here, and we're going to ask you to return a verdict of not guilty on all counts. The judge will tell you that last day, he'll tell you the law. If you can reconcile the evidence upon any reasonable hypotheses consistent with Nick's innocence, you must return a verdict of not guilty. Okay, just one more time. The judge will tell you, if you can reconcile the evidence on any reasonable hypotheses consistent with Nick's innocence, you must do so. You must return a verdict. Only reasonable hypothesis in this case is he feared for his life. That belief was not unreasonable. They created that world to get that environment. In that world, he believed it in that moment. And that's reasonable, because anyone in that situation would believe the same. So at the end, we'll ask you to do your duty.
In a moment, we will hear from the state's first witness. Members of the jury, members of the gallery, if you want to stand and stretch, you may. We are not going to take a recess.
All right. So that was great. Great. Very good. Very good defense opening. I like this guy. Very good use of graphics and the images. Good narrative of self-defense. Put everything in a timeline. Fragility of his patient. Let's see. Let me hit the high points here. Let's see. Defense. Yeah, some of the graphics were really very good. Let me see if I can open those up to share. Of course, I know I can. I just have to. Let's see. Like this one. That's great. Shows the outnumbered people, how far he was from his group, separated from his group, couldn't get to them. Moving backwards would put him in deeper water. That was very good. This one's great. That right image where you see the hands on his throat. Someone puts their hands on your face and throat. If they were by themselves, would that be a reasonably perceived deadly force attack, one likely to cause death or serious bodily injury? Yes. And of course, he's not alone. Outnumbered, what, 13-1? And those are the hands of the one person who was killed. So that's the murder charge. Let's see. Any others I wanted to highlight? This one is great. Goes to his fragility. You know, part of whether or not a threat represents a deadly force threat is whether it's likely to inflict death or serious bodily injury. You can have a threat that against a healthy person would not be likely to inflict death or serious bodily injury, and therefore it's a non-deadly force threat. But that same exact threat against someone who's unusually susceptible to death or serious bodily injury becomes a deadly force threat. We saw what this guy looked like. The not fit is putting it mildly. And the people he's fighting against are all much younger, fitter, stronger football players than he is. Let's see if there's another one. I think those are most of the ones I wanted to highlight. So I really like that graphic with the this one here. They should make very good use of these. In fact, I would have written deeper water here at the upper part of this graph to make that even more explicit. Let's see. The timeline of the when they first go hands-on, the ongoing nature of the attack, it's not stopping. They're pushing him down into the water. Again, multiple aggressors. It's escalating. It's getting louder. They're fabricating threats against him, which would induce people to violence, that he's some kind of little girl looker. The state spent a lot of time talking about he could have walked away, and the defense did a good job talking about, well, these aggressors could have walked away. They could have floated by. They could have gone in another direction. The truth is, the only people who have a legal duty not to close proximity or to move along are the people who are the initial physical aggressors. Everybody had a right to just stand there and not bother anybody, including the defendant. No one in the crowd was being reasonable against him. No one was trying to tone things down. I liked the way the defense turned to the yes, this is a replay of Monday's opening statements. I like the way the defense counsel talked about this effort to make a viral video. We've all seen this, right? Where people engage in provocative conduct to get a response out of innocent people, not out of interest for the innocent person, but out of their own self-interest, to put a video they can put on the internet and get a lot of clicks and go viral. So there's an incentive here to have this thing escalate and get more violence. It looks like there's going to be plenty of room for impeachment of the state's witnesses, evolving inconsistent stories, which of course is kind of normal. I think the defense did a good job talking about the defendant's own inconsistent story. Some of that would just be subject to mistaken recollection under the stress of the event. Some of it's just bullshit, of course. You know, that he took the knife from another person. That's going to be something the defense pretty much just gave that up right here. Said, no, it was his knife. He had it. He threw it up in the woods. That's not in dispute. But again, that can be characterized as consciousness of guilt evidence, but it does not change the underlying conduct. If the underlying conduct was actually lawful, but maybe you don't know if it was lawful or not as the defender. Maybe you think you need to lie afterwards. What you did, captured on video, was perfectly lawful, but you lie about it afterwards. That does not make your use of force unlawful. Some of this goes to him being in shock. He just survived a life-threatening attack. Very common for people to be in shock after that happens. Wide-eyed, white as a sheet. Not actively trying to avoid police identification, just moving along with the crowd on the bridge. Not trying to change his appearance. Those were just the clothes he wore before he got in the water. You'd kind of expect it to be the clothes you'd wear after you get out of the water. If you're in shock from stress, it also makes you feel cold. And just getting out of a river and standing around can make you feel cold. So good job. What happened? Not a big mystery. What did he believe? It has to be from his subjective beliefs. And were his beliefs reasonable? They really have to focus on this because I believe the state has motioned to disallow perfect self-defense and only allow imperfect self-defense. So to make sure you don't lose perfect self-defense, you have to make sure that there's evidence that your client's perceptions, decisions, actions were objectively reasonable. But yeah, this that image with the hands to the throat here, very important, because the one person who was killed is 17-year-old Isaac Shuman. We already saw in the state opening, they're going to put all these cute pictures of him up. Nice kid. Everybody loved him. Great aspirations. Was going to cure cancer. All this stuff. He was also doing this. And a blood alcohol level, what did they say it was? 0.2? something? I wrote it down. .219. What's drunk driving in Wisconsin? Probably 0.18, 0.08. .08. So it's almost 3 times the legal limit for drunk driving. Do people tend to act more reasonably when they're drunk or less reasonably when they're drunk? If the defendant would have perceived their state of intoxication, would that make them more fearful of their likely escalation or less fearful? Comments are telling me it's 0.08 everywhere now. I'll take your word for it. I don't do DWI law. I guess I would have to ask the DWI guy. 0.219 and still walking around, 17-year-old, not his first time drinking. Yeah, most people wouldn't do well at 0.2. Although I did do a murder case where the victim was 0.458. 0.458. He was, however, a lifelong street living alcoholic. Yeah, so just a personal anecdote. Just a few years ago, I was in Mexico on vacation with my family, holding then my little 5-year-old in my arms in the pool. And some steroided up dude decided he wanted to yell at me and threaten me with death in the swimming pool. So it didn't escalate. I didn't allow anything to escalate. If it had escalated, that guy probably would have had a bad day because I was not unarmed either. And I would have to be concerned not just about somebody drowning me in the pool, but my 5-year-old couldn't swim. So that would have been a bad day. Fortunately, it wasn't a bad day for him. And it wasn't a bad day for me. And I didn't have to explain things in a Mexican prison afterwards. But it could have gone that way. I mean, I have no magic power that kept that other guy from not escalating. If he'd wanted to escalate, he could have. So, no, I didn't bring a gun to Mexico. But Mexico has knives. Yeah, I did have to throw the knife away by the end of the trip because it corroded pretty badly. That's why I buy inexpensive folding knives. It got thoroughly corroded. You can carry a knife in a pool. I wouldn't recommend doing it with a knife you care a great deal about. All right. What else? I think I'm going to, I'll take a look at the comments, do some Q&A. So as usual, we answer all the questions from Law of Self-Defense members in the member live stream for free. If you're on YouTube and you're posting questions, whoops. Sorry. If you're on YouTube and you're asking questions, they need to be a $10 super chat minimum. Or you could do the smart move and just become a Law of Self-Defense member yourself. Get all your questions answered for free. You can become a Law of Self-Defense member for just 99 cents. 99 cents gets you a 2-week trial. Would cover the entirety of this trial, I expect. Get all your questions answered for free. After the 2-week trial, it's still dirt cheap. It's only about 30 cents a day, less than $10 a month to be a Law of Self-Defense member. But at least try out the 2-week trial for 99 cents at lawofselfdefense.com/trial. Or post your questions on YouTube, but it's got to be a $10 minimum super chat. And I'll also mention again, our sponsor for today's show is none other than Law of Self-Defense itself in the form of our upcoming Law of Self-Defense advanced class. This is a full day class taught live by me, streamed to you at your computer. We only teach it twice a year, folks. The next one is Saturday, April 20th. It's the course that teaches you everything you need to know to be hard to convict if you're ever compelled to use force in defense of yourself, your family, your property. We talk in great depth about the 5 elements of self-defense. We talk about defense of yourself and of others, family, colleagues, neighbors, strangers. They're all different. We talk about defense of property, both highly defensible property like your home or business or occupied vehicle, as well as least defensible property like just an unoccupied vehicle, your stuff, your pets, believe it or not. Your privilege for using force, especially deadly force, varies enormously depending upon the class of property. We spend an hour or so talking about interacting with the police in the aftermath of a use of force event. There's at least 3 different types of police interactions you need to be aware of. We talk about how you can devise your own customized, legally sound self-defense strategy and a lot more. But we only teach it twice a year. If you miss this April class, it'll be at least October before we do it again. Can you afford to wait? Do you know when you're going to be attacked? That's up to the bad guy, right? Time, place, and manner of attack. This defendant wasn't planning to be stabbing people when he went floating down the Apple River, was he? So you can't afford to wait until October or some later date to get up to speed on how to be hard to convict. You need that information on board before the fight happens, meaning doing it sooner rather than later. And sooner is Saturday, April 20th. You can sign up right now at lawofselfdefense.com/advanced. And by the way, if you have a conflict on that April 20th date, there's the banner right there, lawofselfdefense.com/advanced. If you have a conflict on Saturday, April 20th, if it's a nice day, you'd rather be out than sitting at your computer, register anyway, because we'll make the recorded playback version of that class available to all the registered students for at least 2 weeks. So you can watch it over your leisure during that 2-week period. But you have to be a registered student. And if you sign up right now, it's still 50% off the standard registration. Again, you can do all that at lawofselfdefense.com/advanced. All right, so let's take a look at our member Q&A. Pull it over here so you're not looking at the side of my head. All the usual suspects. Kyle, Paul, Clay, these are all self-defense members. Cycle Boy, Tony D, Jeffrey. Some new members. That's always nice to see. Cycle Boy asked me to turn on closed caption. Sorry, I'm only seeing that now. I do try to do that. I just forgot. My apologies. Cycle Boy says, they call him a graper. Isn't that a breach of peace potentially? Well, I mean, I don't know that I would go that far, but he knows he's being called a rapist. He knows people don't like rapists. We all hear people talk about racists when they're on the internet, on social media, right? Well, I would take care of that rapist. So he would know it's likely to escalate the risk of violence to himself at the hands of these. Matthews asked if these boys are under 18. I think, well, the one who died was 17 for sure. I don't know the ages of the others. Steve Gosney. Hey, Steve Gosney, Attorney Steve Gosney, Public Defenders, Appellate Division, Florida. Look how innocent he portrays the kids and how sinister he portrays the defendant, talking about the prosecutor's opening. Indeed, that's what they do. Kyle Cowden says it was found he was justified under fighting words, either a trial. Oh, that's a different case. Just some innocent teenagers having a good time, and the mean old guy they surrounded ruthlessly stabbed them. Yeah, that's the state narrative. Philip says, not sure if anything good can come from confronting a group of potentially drunk, entitled teenage males preening in front of their girlfriends, but that's just me. And I agree, Philip. I wouldn't go near this group either. But that's not an element of self-defense, and it's not provocative, and you know, mere poor judgment doesn't lose you self-defense. That said, good judgment's helpful to have in life. There's a reason I've carried a gun every day of my adult life, and I've never come close to needing it, because I'm sensitive to these kinds of risks, and all of you should be too. The punch to the girl, of course, that's probably like the initial act of physical force. But of course, the defense says that's not a punch. It was at worst a shove. And in fact, you can be the first person to punch. You're not required to wait until someone actually uses force against you. You're allowed to defend yourself against an imminent threat of force. And remember here, the imminent threat of force is not just the threat from the girl. It's the collective threat of everyone arrayed against him. It's not like she was there by herself. The knife came out before anyone hit anyone. Yeah, but he's not using it. The question is, when does he start using it? That's the use of deadly force. The prosecutor made a big deal saying, you know, he wasn't brandishing it, he was hiding it. But if he had been brandishing it, there's no right answer for the prosecutor. If he'd been brandishing it, they would have charged him with brandishing too, and said, well, there was no imminent threat against which he could be justified in brandishing the knife. So it's always the wrong answer with the prosecutor. Just like the prosecutor talked about his affect, how he was presenting himself. He was stone-faced, I think the prosecutor said. No matter what your affect is, it's the wrong one. If he'd been crying, they would have said that was consciousness of guilt. He knew he'd murdered somebody. Yeah, I think this defense has a good representation that this defendant did actually walk away. So the state kept saying he could have walked away. He could have walked away. It looks to me like he was walking away. But keep in mind, your duty to walk away. Well, first of all, there is no legal duty in Wisconsin, but even if there was, it's only if you can do it with complete safety. Yes, when I say people should have a lawyer, I mean a competent lawyer. Competent lawyer. Kyle says, if you read Andrew's book, I guarantee you'll know more than the majority of lawyers. Yeah, that's right. Because lawyers aren't really taught this stuff. Again, you can get our book, read it, check it out on Amazon. It's well rated, but don't buy it there. They'll charge you for the book and the shipping and handling. We only ask you to cover the shipping and handling. lawofselfdefense.com/free book. We give you the book for free. Real physical book. We mail it to you. You will like it. Everybody likes the book. Written in plain English. Most people tell me they read it in an afternoon. Kyle says, Law Self-Defense Chat. I love the ability of our community to discuss debate without the typical rancor of the tribal internet, probably due to an innate level of maturity intrinsic to those that would frequent here. And Jeffrey says, agreed, Kyle. Andrew has moved us to a higher level of human existence. I don't know about that, but the fact that you made the affirmative decision to become a member of this community says something about you, right? Anybody can throw cheap shots on an internet chat. Jeffrey says, I went through 1 year of law school, so I took criminal law. I can't remember any talk of self-defense. Yeah, I think I had about 5 minutes of instruction on self-defense law in 3 years of law school. And all of that was first-year criminal law. Philip says, are the DA and the defense talking about the same incident? No, they characterize it very differently, right? That's what I always tell you. The state and the defense, what the jury's hearing are two competing stories, two competing narratives, a narrative of guilt from the state and a narrative of, if not innocence, then not guilt from the defense. And as the finder of fact, the jury gets to decide, has in its entire discretion, which narrative, which story they want to believe. Philip says, about hitting a female, watching law enforcement body cam videos, drunk young women are too often incredibly aggressive, violent. Yeah, that's true. And you see the facial expressions of that chick, right? She's not afraid of being aggressive. I wonder if I have that image. I can't find it immediately, but it'll come up again. Yeah, I forgot. I know. I forgot to enlarge the court video window for the defense opening. Sorry, folks. Nobody comes here for the production value. Will Parker says, incidents like this, and I'm always armed, are reasons I've not had even a drop of alcohol in more than 14 years. Reasonableness. Yep. I get it, Will. Will says, not even at home. You never know when or where it will happen. Yeah, that's true. That's true. All right, so those are all the member comments. Let me take a look at super chats to see if there's anything there. $10 minimum super chat if you're on YouTube and you want that addressed, folks. Dirt Cheap sent a $5 super chat, but I'll read it anyway. He wanted me to make the court window bigger. I'm sorry, folks. It's hard for me to actually be paying attention to the video I'm watching and remember the production stuff. If anybody wants a job doing real-time production on my shows, let me know. We can work something out. There are a lot of plates involved in producing these shows, and I drop them. I drop plates all the time. A lot of little details. I would much prefer not to be doing that stuff myself. Trust me, that's not my area of highest strength. Okay. So that was the opening statements. I do have to take a break, folks. I have a commitment in about half an hour I cannot avoid. But I think I will schedule a part 2 for this afternoon. So I'll email that. It'll go up on YouTube as a premiere show about to come up, probably about 3 p.m. Eastern time. And I'll see how many witnesses I can cover in this case before I have to clock out at the end of the day. All right. So until then, I just remind all of you, until a couple hours from now, 3 hours from now, I'll just remind all of you, like in 2 hours, I expect to be back. I'll just remind all of you that if you carry a gun, so you're hard to kill. That's why I carry a gun, so I'm hard to kill, so my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. See you all in a couple of hours. Until then, stay safe.